Go ahead and call the meeting to order. Good afternoon, everyone. I hereby call to order the Code Enforcement meeting of October 9th. Thank you for coming to today's Code Enforcement Board meeting. This board is empowered to hear evidence, to reach findings of fact and conclusions of law for the purposes of resolving cases that come before it. A finding of violation may lead to the assessment of daily fines in the form of property liens. The board is always interested in statements that will help us make a determination in each case, and we are interested in compliance rather than in levying fines. We will hear all cases in the order that they appear on the agenda, beginning with new violations, fine assessment cases, or status updates, and concluding with the cases for which persons are seeking fine reductions. We will begin by having all people who are speaking before the board today sworn in. And if you could.
Witnesses, if you're a witness on a case or you're a property owner and you want to talk, please stand up and get sworn in.
Hang on one second. Did you want to do the roll call first so we have a quorum?
Yes, we can do the roll call first.
Please, thank you. Wayne Pasick, absent. Stephen Butera,
Present.
Jimmy Canton,
Present.
Richard Burgess,
Present.
Todd Leheroux,
Here.
Jennifer Jones, Robert Cohen.
Here.
All right, thank you. We have a quorum, and then did you want to approve the minutes?
Let's go ahead and get people sworn in, then we'll do the...
Okay, there we go. So then it's this one, right? And then the quorum, right. Please raise your right hand. By authority vested in me as a notary of the state of Florida, do you swear and affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right, board members, we have minutes from May 8th, June 12th, July 10th, and August 14th of this year. Can I get a motion? We can approve them in block if if everyone feels like they are satisfactory. If there's any questions or issues about the minutes, we can do them individually.
I make a motion that we approve the minutes as submitted. Second.
Any discussion? All those in favor?
Aye.
Any opposed? Minutes are approved. Okay, do we have changes to the agenda?
Yes, sir. Changes to the agenda. Postponed cases are as follows. Code 2500164 prior to the hearing. That's the only one that's postponed. And then I have compliance or closed cases are as follows. Case number 2025004555. Code 25000095. Code 2500116. Code 2500125, Code 2500133, Code 2500137, Code 2500141, 00141, Code 2500143, Code 2500146, Code 2500147, Code 2500148, Code 2500149, Code 2500152, Code 2500156, Code 2500157, Code 2500166, Code 2500167, Code 2500168, Code 2500169, Code 2500175, Code 2500176, Code 2500180, Code 2500182, Code 2500185, Code 2500186, Code 2500187, and finally, Code 2500188.
All right, thank you.
May I have a motion to postpone the case number that the code enforcement staff would like to postpone? I believe the last three were 064 in the beginning.
Yeah, is that number 13 on the agenda? Is that the one?
Madam Clerk? Yes?
Okay.
Case number 13, Code 2500164.
Can I get a motion to postpone that case to a future hearing?
Mr. Chairman, I'd like to make a motion that we postpone case number 2500164 to a future meeting.
Second.
Thank you. Any discussion? All those in favor of postponing?
Aye.
Any opposed? Motion passes. Ms. Warren, do we have any cases that we want to move up on the agenda because they have someone present today?
We have a lot of people. I don't believe that code enforcement staff checked individuals in, or nor was I notified of any urgencies. We can probably just go down the
Okay.
agenda. However, if the board would like, if they call a case and no one is present, to move on to the next case to accommodate those present, then the board can do that as well.
Okay, thank you.
You're welcome.
All right. I believe we are ready to call our first case.
First case, 2025-004957, property owner 400 West Atlantic LLC, registered agent Lawrence Blair, registered agent, property address 404 West Atlantic Avenue, presented by Code Officer Delinda Witkowski.
Is there anyone present to speak on this particular case? Okay, hearing none, we will go ahead with the case.
Good afternoon, Mr. Chair, board members, magistrate, assistant city attorney, and distinguished guests. My name is Delinda Witkowski. I'm a code enforcement officer for Clean and Safe. I'm here regarding an unapproved violation, signage violation located at 400 West Atlantic Avenue. On May 24th of 2025, I inspected the property where I observed several temporary banners that had been hanging for an extended amount of time without the proper approvals, which is in violation of Code Section 4.6.7, subsection F, subsection 1, which states that all signs need approvals by the city. A general violation was issued on May 24th of 2025. The violation was mailed first class and certified on May 29th of 2025. Compliance date was requested for August 14th of 2025. Because this case was a legacy case, which was the previous system that we had was AS400, another violation was issued through EPL, and this violation was mailed first class and certified on September 16th of 2025. Certified mail was not received, regular mail was not returned, posted at City Hall and hand-delivered on September 17th of 2025. A reinspection prior to hearing was conducted on September 30th of 2025, and as today, the violation continues to exist. I do have 5 photographs that I would like to introduce into evidence. I have had some contact with the property or with the business owner and with a couple of the managers.
Thank you. I'm now showing you it has been previously marked as City's Exhibit 1 for identification purposes. Do you recognize this?
I do.
And when was this photograph taken and what does it depict?
So this was when I saw the violation occurring, which was on May 24th of 2025, which is one of the banners on the building.
And is that the banner you're referring to at the kind of like the top part of the building?
Yes.
And is there any instance where something like this would be approved in the city?
They are approved. Temporary banners are approved by our Muni Code. They are approved for a period of 4 weeks and only 1 banner per building.
Okay, so in this case, at some point this became a violation.
Correct.
Okay, thank you for the clarity. City's Exhibit 2 for identification purposes?
You'll see a couple more. So I think in total we had 4 hanging banners without approvals.
And are you referring to the banner that says Grooves on the bottom and the one that says now open 9 a.m. daily
Yes, ma'am.
in the photograph? Thank
Correct.
you. And that was also taken on May 24th, correct?
Correct.
What about City's Exhibit 3?
Okay, so this is just reinspection that we do by our standards that we requested for September 30th was the day that I did the reinspection prior to hearing. And
Okay.
the banner continues to be hung.
And you're referring to the banner above the entry doors that says Grooves, correct?
Correct.
Thank you. City's Exhibit 4 for identification purposes?
Here's the other banner. One kind of fell and is hanging on the corner of the tent and the building, but the other one, I guess they removed it.
And is that the sign that you're referring to on the bottom,
Yes.
kind of middle of the photograph?
Correct,
that says
that's a
Grooves?
temporary banner.
And that was taken on September 30th?
Correct.
Thank you. I'm now showing what has been previously marked as City's Exhibit 5 for identification purposes. What does this depict?
Okay, I know that it's hard to read, but there are several banners and stuff that had, they were issued permits and approved, but they were technically for the building next door, which is the smoke shop.
Okay, so let's talk about that. So when you say, do you mean the building, this particular building, the 400 West, it has different businesses there, correct?
Correct, it's just one parcel though.
All right, so I see here that there are different signs. For clarification, none of those signs apply to the business Grooves located at the 400 West Atlantic 404.
Correct. Yeah,
Okay.
actually, the restaurant is 404, but the parcel is actually under 400 West Atlantic. So this is actually for a different shop, not for the restaurant.
So this particular image here depicts a lack of approved sign, correct?
Correct.
All right. At this time, the city would like to introduce the 5 exhibits into evidence.
Can I get a motion?
So moved.
Mr. Chairman, I move that we admit the 5 documents and pictures submitted by the code enforcement officer into evidence.
A second.
Do we have any discussion? All those in favor?
Aye.
Any opposed? Documents are admitted into evidence.
All right. What is your recommendation?
Because of the lack of trying to come and getting approvals for the permit, we, as a city, we request 5 days for the removal of all the banners, temporary banners, or $100 per day thereafter for noncompliance.
Thank you. Board members, any discussion?
I had a couple of questions for the officer.
Yes, please, go ahead.
I didn't understand, had you approached the owner or management regarding this topic?
I have.
And you advised them that they a permit, and if they had a permit, it would only be good for 4 weeks?
Yes, they're aware of that.
Thank you for letting us know that.
Correct.
Mr. Chairman, in light of that, and I'm not on the downtown boards or anything, but it doesn't seem fair to other businesses that are obeying the rules. So I think $100 a day might be a little bit light in that it's a commercial violation. I wonder if any other board members
I have a
have a
couple
thought.
of questions. Can we see the pictures again?
Yes. Which exhibit would you like to see?
Well,
Want me to start from the
so
top?
the banners are a part of this restaurant Grooves, correct?
Yes.
Okay, so that's what's in question. Can we go to the picture of the awning,
The tent?
the tent? Is that tent permitted?
They're currently-
No, they're currently trying, but as of now, it is not permitted.
So if another business had that tent up, it would be all right also? Is
Well,
it bolted to the ground or the fixture of the
okay.
building?
So may I just interject here?
It's not in,
If we could please stick to the current violation, we don't want to say anything
Well,
about
there's-
anything else potentially going on with this, and also it's irrelevant what else is happening, is happening with the other businesses as well.
Thank you.
Is there anyone here that owns this property or no one showed up?
No, they didn't show up.
So the only thing we're questioning right now are the banners.
banners.
Correct.
And then
As
we
of
could
now.
down the road have to question that tent.
We're not going to speculate on what you
Okay,
may
no,
or
I'm
may
just-
not
I'm just
have to.
curious. Okay, so have you gotten a positive response back from either the tenant or the landlord about the violations?
No, no positive response.
Okay.
I thought that's what I just asked her.
Yeah, no, because there's a reason why I'm asking, because it's insult to injury for city staff, because the manager of the facility is also on another board, and it seems like he's got a.
We don't wanna go
We-
there.
That's,
I really
that's not
appreciate-
really relevant to the.
We have to really stay just on the one
Yeah.
case and
Yeah,
on our
ju-
board.
just to clean us up a little bit, this board should not consider anything other than the evidence presented to it.
I would like to add to my fellow board member, this violation, if we don't add, I think, a little higher violation, I think we're allowed to fine up to $1,000 a day, am I correct?
That's correct.
So something more appropriate, perhaps, and I'm only suggesting, perhaps $100 per banner, so that would be $400.
For a day.
Yeah, something, because it's not fair to other people who own businesses. They can't put up or any organization can't just put one up without a permit, right?
Are you allowed to put one up temporarily while you have like permits in for permanent signs?
Yes.
Absolutely, they can
Okay.
get approvals for a
4 weeks.
temporary ban, which is a period of 4 weeks, one per building.
And they did not request
opening
a
They-
permit
they didn't
for the
got approvals for
temporary
anything.
nor for any permanent signage at this time.
Correct.
And you re-inspected in the last 48 hours?
No, our procedure has been done differently now,
Okay.
so we do it we can do it up to 10 or something. It's done differently, so it was done on the 30th, but yes, it's still there.
I mean, let's just be clear, you patrol this area, and as of the
I'm
last
constantly up and down every day.
I mean, I drove past there today, so
Right.
I
So
know.
did I.
We
That's
don't
not
base anything
evidence.
based on personal observations,
That's
only
not
evidence
evidence.
presented.
Okay, do we
Just
have a
one
motion?
quick correction for everyone. The officer recommended that you order the removal within a certain amount of time.
Right.
I would recommend that the board not order any type of compliance type, because as in many cases, and this one is also true.
Multiple ways to get to
There are multiple ways
compliance.
to get to compliance, but give them a time frame to come into compliance.
Would the fines be assessed against the tenant or the property owner?
They always go against the property owner.
Okay.
Because that's where the lien goes.
Would you like to make a motion?
I will this time. Thank you. And thank you for your questions. I find them insightful. Mr. Chairman, I would like to make a motion with respect to the case number 2025-004957. I move for a finding of fact and a conclusion of law that there is good notice and that the violations of 4 banners being displayed without permit exist on the property. The offending party shall correct all violations within 5 days or pay a fine of $400 per day for each day thereafter. For non-compliance, the respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board, and in the event of non-compliance, a lien for the daily amount shall be imposed upon the property.
Second?
I second.
Do we have a
Thank you.
discussion? Do we have a discussion on that?
Yes.
I do agree we need to get their attention, but I don't think 5 days is reasonable time for them to be able to respond. So we give them a little bit more time.
How much time?
I would like to have a discussion. You know, I want to.
I mean, I'm inclined to disagree with that. They're an active practicing business. All they need is a pair of scissors and they're in
It wouldn't take
compliance.
5 days to put them up.
Okay.
So,
That's the thing.
I mean,
okay.
normally I would be in agreement with you. If it was a different kind of violation, I would be 100% in agreement with you. But in
I
this
can
case,
take that. I agree with that. We can-
I'd like to add to Jimmy that the officer's testimony was from, he asked her and I asked her, have you consulted the manager about this? And they know, they're aware.
Right.
I would just add, the standard for the board is that you have to give them a reasonable time to come into compliance. What that means in practical effect is that there has to be enough time so that they can comply with your order, and that's the assessment that you should make.
So if my colleagues thinks 5 days is fine, I'll agree.
any other discussion?
If the fine has to be heavier to move the needle, I would agree to a heavier fine, but, $400 a day should get it cleared up. And that starting today doesn't go back from the original violation, correct?
It starts
No,
from
it
when
starts-
they, actually when
Yeah,
they
the way
receive
that the order is
notification.
drafted, the fine would begin to accrue after the expiration of the 5 days that you've given them to comply.
And the property owner, again, was notified of all this, correct?
All our letters are certified in first class go to the property owner, which is on property appraisal, and any business that has a registered agent.
Now, just for point of information, the tenant for Grooves are they the property owner or they're just a tenant?
They are tenants.
Okay, but the property owner is the one who's going to get the fine.
Correct.
Thank you.
And, any other discussion?
Can I just,
Good.
one second. One moment, I just want to check with something with Development Services
Okay.
to make sure that they don't have anything else that might be in the works. One moment. Sorry, I just wanted to double check with Development Services that there were, this wasn't a part of any other approval, just to confirm.
Okay,
But she told me she wasn't aware of anything. Thank you.
all right. No other discussion, we'll call a question. So all those in favor?
Aye.
Any opposed? Thank you. Motion passes. And next case.
Next case, 25025. Case number, sorry. It's a typo in there. 2025-005-157, property owner Rosebud Ray Shops LLC, registered agent CM Rack Inc., property address 245 Northeast 2nd Avenue, presented by Code Officer Delinda Wachowski.
Thank you. And you're here for that property?
Yes, I am. I'm the
Okay,
property
and-
manager, Abby Reich Bennett.
And your address?
Get my office address or their address?
Your office address?
101 Southeast 4th Avenue in on Delray Beach, 33483.
Thank you. Okay. Ms. Warren?
You may proceed.
Good afternoon. My name is Delinda Witkowski. I'm a code enforcement officer for Clean and Safe. I regulate the downtown, which are the restaurants and the businesses. I'm here regarding a clogged French drain on private property located at 245 Northeast 2nd Avenue. On June 3rd of 2025, I inspected the property where I observed a French drain that had been clogged and flooding the parking lots with rain, which is in violation of Code Section 56.20, subsection A, subsection B, which states that the property owner shall be responsible for the stormwater drainage facilities located on private property, where runoff will principally be collected within the property. The owner shall clean and maintain the facility or channel as required to ensure efficient and proper operation of the facility. A general violation was issued on June 7th of 2025. The violation was mailed first class and certified on June 10th of 2025. Compliance date was required for June 21st of 2025. Because this also was a legacy case from our older system, AS400, another violation was sent out through EPL, and the violation was sent first class and certified on September 16th of 2025. Certified confirmation was not received, regular mail was not returned. It was posted at the property and City Hall on September 17th of 2025. Reinspection was done on October 3rd of 2025, and as of today, the violation continues to exist. I do have 4 photographs that I would like it to introduce into evidence.
Okay.
Again, I have had contact with Abby. We actually did go out there with Public Works. We discussed it and to see what was the best option as to how to correct the
And
violation.
handle it.
That was my next question. Did you consult with anyone from Public Works or
Yes,
someone
we
with
did.
the stormfront? And did they confirm that that there was an issue with the drainage?
They did. I do have an email here from him, but so.
Just tell me what.
Huh?
what
Yes,
their-
we did. He confirmed everything that what needed to be done and that there was an issue and it needed to be resolved.
Okay, thank you. I'm now showing it's been previously marked as City's Exhibit 1 for identification purposes. Do you recognize this?
Yes, this was taken on June 3rd of 2025 at the parking lot.
So is this when you first note, like, one of the times that you noticed that this issue?
Correct.
All right, and you're referring to the amount of water, standing water in the parking lot?
Yes, it was just a buildup. It wouldn't drain, so it stays several days or 72 hours, but becomes an issue with mosquitoes.
All right, City's Exhibit 2 for identification purposes?
This is just another close-up photo. You can see the French drain there that was taken in the initial violation on June 3rd of 2025.
Okay. And could you describe the what's in the photograph?
Describe it?
Yeah.
So you can see there the drain, the French drain, and it just has like about 3 inches of water there.
Perfect, thank you. City's Exhibit 3 for identification purposes?
Okay, this was our reinspection photo taken on October 3rd of 2025. Yeah, I had to
So if
kind
you
of,
just-
it rained, but it does accumulate a lot of water there.
All right, so you just described that there's lots of water near the drain.
Correct.
Okay, thank you.
And this, again, is just a close-up on, that was taken a reinspection prior to hearing, which was on October 3rd of 2025.
All right, and then could you describe what's in the photograph, please?
I'm sorry.
Can you describe what's in the photograph?
So it's the French drain, just a closer look of it, covered with water with 2-3 inches of water.
All right, thank you.
So,
At this time, the city would like to introduce the 4 photographs into evidence.
I move that we admit the documents, the 4 pictures submitted by the code enforcement officer, into evidence.
Second?
Second.
All those in favor?
Aye.
Any opposed? Thank you.
I did receive a proposal from Abby today, actually, when I got to work. I printed it out, and it looks like they are working on it, so if she wants to...
Tomorrow morning, they're doing it.
Okay.
They're gonna jet the drain and vac everything tomorrow morning.
And if you can clarify what the compliance date was.
So compliance date was, June, it was of June, the 21st of June.
All right, thank you.
And what does the city looking for in this case?
Did you want to hear from
Yeah, I
the
guess you have
respondent
opportunity to question the witness initially and provide any rebuttal or testimony as well.
At this point, I mean, I got a contract with Shenandoah, and because we've been working on it for the last 30 days, I did have one of my contractors come out, but it failed. So now I've hired Shenandoah, and they're coming out tomorrow morning to jet and vac the line. I just asked for a little bit of leniency so I can at least get this done in the next week.
Okay, thank you.
Question? From either. This is the inlet to a supposed French drain, which is a funny word because it doesn't really mean anything in the engineering business, but that's agreed to. But my question is, what is the discharge outlet situation? To what does this French drain discharge? Who owns the canal at the outlet end?
I don't know the
There's
question.
actually not a discharge on the same property. So it's an older construction, an older parking lot. So technically there should have been, but there isn't.
Is your contractor going to somehow connect your French drain to some receiver that can accept that much water?
At this point, they're just cleaning it out and basically jetting it and vacuuming out any of the dirt, because I guess the dirt is quite impacted into the drain.
It doesn't answer the question. Where does the water want to go? Is it possible that there's a blasting it out with a hose or something isn't the same as putting in a pipe that's really maybe needed? I mean, you need to really have an engineer tell you what to do. Otherwise, you may not be getting anywhere.
Well, can
so
I just...
my question is, what is your contractor proposing to do?
I'm
Tell some detail.
going to cut you off here because I don't think that's the results are necessarily the response to that question necessarily answer what we need to know in order to determine whether a violation exists. You're looking at whether or not her proposed solution
I'd like to hear the
is
city's
significant,
proposal
but-
first before we know how much. What are the time constraints? What is your
Mr. Cohn, that's why they hired a professional, but the city's suggestion is 14 days to clean the exfiltrated trench or $100 per day thereafter for noncompliance.
So 14 days to come into compliance. Thank you.
Question then is, does your contractor told you that that's enough time to do the work that they anticipate encountering?
As of right now, we're going to jet and clean. We're going to see basically what it looks like, and we're in hopes that there's no intrusion from roots or anything like that. But as of right now, the first step is to jet and vacuum the French drain.
All right. If at the result of that tests show there's still a problem,
We got to continue on and do
some
something. Yes,
All right.
absolutely.
would you then ask for some extension of time now that the problem is?
Yeah, then we come back in front of you guys and ask for more time with some plans from Shenandoah, because they are a contractor that does this.
Other questions for the witnesses?
What was the city's position on the drainage issue with Public Works?
What do you mean as far as?
I think that the Public Works confirmed that there's no connection to the city
Yep.
drain system, which is why they're totally
Because there's
responsible
other
for
buildings
this.
in the area that have had similar issues with water and sewerage. When stuff was constructed, some of the older buildings, they didn't tie in.
Right.
And that parking lot, I remember going to the Chinese restaurant in Christina's 15 years ago when it rained, had a drainage issue. So I think it's, they're trying to follow due process and get it cleaned out at least, but I would suggest, like, seriously speaking with Public Works to see where the problem lies, because it's been a drainage issue in that area for a long, long time. I've seen that just driving by myself.
And I do have a question to expand on that. That was my question. was the drainage issue there before these tenants got there? Because if they do everything
It was.
possible
It was.
to fix it, then what?
Definitely.
Right? What if they clean it out?
And they're responsible for the condition of the property as the property owner.
Property owner has to maintain it.
Yeah, definitely.
Okay.
I think it might fall on the city side once they clean it out.
It's property, it's private owned.
Yeah, I've tried to get the city out there several times, and every time they told me it's privately owned.
Yeah, it's not connected to the city, so it's not a city drainage issue.
I mean, the conversation's gone in a a solving direction, which probably is not great, but it is okay for you to consider what the respondent needs to do to come into compliance and to give them the appropriate time to do so. That is certainly within your
Right.
purview.
Just one other, I'm not familiar with this part of the city. Does this part of the city, is this served by the Lake Works Drainage District?
I don't think so, no.
Southern, you know that?
I don't
Southern
think so.
Southwest Florida Water Management District, are they have any responsibility for a discharge location in this part of the city?
I don't think so, no.
No, I don't think so.
So does the city maintain something downstream of where this property transitions to somebody else's property that has an outlet designed to work? or-
Wherever it is city property, the city will maintain it. If it is private property, the property owner has to maintain it.
I understand, but eventually the water is going to pass the property line of this owner's property.
That is beyond my
Where-
knowledge.
I understand. So who's responsible for getting the water from the edge of from the property line of this owner someplace else?
Mr.
city?
May I?
I don't
The
think
city,
that's-
the owner can't be responsible
nothing
for
to do,
anything
move
past their
forward.
Ms.
property
Warren,
line.
please.
No, what I was going to say, right at this point, the city is asking for 14 days for them to come into compliance and a fine thereafter. Sounds like the board is considering what time is reasonable. I think the compliance, the respondent has already stated that she's been in contact with the city, has already hired a professional, so they're already taking measures to come into compliance. So I think that any conversation beyond that, I think we might be getting a little outside of the scope of the hearing.
Mr. Chairman, can I make a motion?
Yes.
Based on Ms. Warren's
Yes, please.
testimony, and we do have, she is trying. We'll take the city's recommendation that will give them 14 days to come into compliance.
And why don't you give the full motion?
Oh, I'm
then?
sorry. Now, how much penalty did you say after 14 days?
14 days, $100 fine is what the city was asking.
Mr. Chairman, I'd like to make a motion with respect to case number 005157. I move for finding of a fact and conclusion of law that there's good notice and that the violation of the city drainage exists on the property. The offending property shall correct all violations within 14 days or pay a fine of up to $100 per day for each day thereafter for noncompliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board. In any event of noncompliance, a lien of the daily amount shall be imposed on the property.
I'm sorry, I'm gonna have to correct you on that. You said city property.
I'm sorry.
You said-
Yeah,
Well,
it's
private
not, it's
property.
private property, so you're gonna have to reread that.
So reread it again?
Yes.
I think we can
I don't think you have to
amend
Right.
your wording to say private.
Or
Yes,
just
we
say
can make that
correction.
Correction,
private.
private property.
Thank you.
Second.
Moved and seconded. Any other discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes. Thank you.
Thank you.
Thank you. Thank you, Abby.
Okay, next case.
Next case, code 25000056, property owner Selena Development LLC, registered agent CT Corporation System, property address 32 Selena Avenue, presented by Code Officer James Easley.
And do we have anybody present for this case? Anybody, property owner or somebody wishing to speak on this particular case? Okay, go ahead.
Good afternoon, Code Board. My name is Code Enforcement Officer James Easley, Clean and Safe Unit. I'm here regarding case number 25-000056, a maintenance of building required violation located at 32 Selena Avenue, Delray Beach, Florida. On July 9th, 2025, while patrolling the area, I observed a property in need of building maintenance. Upon further investigation, I observed that the property owner needed to obtain all required permits to repair or replace the glass pane to the front entry door, repair or replace the missing or damaged roof tiles, and repair or replace the broken or rusted drip edge to bring this property into compliance. The observed condition of the property constitutes a violation of Code Section 7.8.3, Maintenance of Buildings, which states that all buildings or structures, both existing and new, and all parts thereof, including all materials and fixtures, shall be maintained in a safe, secure, and sanitary condition. Therefore, on July 10th, 2025, this case was established. Notice of violation and notice of hearing was mailed by first class and certified mail on July 28th, 2025. The green card was returned on August 8th, 2025. The notice was also posted at the property on July 28th, 2025. The compliance date was required by August 15th, 2025. On September 11th and September 12th of 2025, I re-inspected the property and observed that the property was still not in compliance. Therefore, on October 1st, I conducted a re-inspection and observed that the violations still exist. I have 10 photographs taken of the property in question. I have had contact with the property representative who has kept the city abreast of their plan and progress towards compliance. To this day, the property remains in a state of non-compliance.
Thank you. I'm now showing it has been previously marked as City's Exhibit 1 for identification purposes. Can you tell us when the photograph was taken and what it describes?
Yeah, this photo was taken on June 9, 2025, and it depicts the front view of the property.
Okay, what are the violations described in the photograph?
Yeah, so when you look at the front door from this angle, right at the bottom is one of the panes that is completely missing. So person can go in and out, animals can go in and out. So it was completely open at the bottom, that bottom pane that you see on the front door at 32 Salina.
Thank you. City's Exhibit 2.
There's a close-up photo showing that the bottom pane is completely missing at the bottom.
And that was on July 9th, and also Exhibit 3 is on July 9th?
Yes, this photo was taken on July 9th, 2025. You can see the condition of the drip edge and the condition of the roof.
Thank you. City's Exhibit 4.
You see re-inspection was completed on September 5th, 2025. You can see they put a piece of plastic at the bottom, but the property still remains in a state of non-compliance.
City's Exhibit 5.
Again, on September 5th, 2025, you can see the condition of the roof and the drip edge.
Thank you. City's Exhibit 6.
Yeah, again, just another angle of the condition of the roof and the drip edge.
City's Exhibit 7.
Again, this is another portion of the property. You can see the rusted drip edge of this property.
And there's also, it looks like some disrepair or damage to the, kind of looks cream or pink
Yes.
area.
Yes, and this was all taken on September 5th, 2025.
Thank you. City's Exhibit 8.
Again, this is another accurate depiction of what I observed in the field. When I did my re-inspection on October 1st, 2025, you can still see the condition of the roof and the condition of the rusted drip edge.
City's Exhibit 9.
Another angle taken on October 1st. You see that this property still is a state of non-compliance.
And what's depicted in here is kind of what you described earlier.
Yes, again, the condition of the roof and the drip edge, the maintenance of the building.
All right, and this is a different side on City's Exhibit 10. What does this depict?
Again, from another angle, another side of the property, based on my re-inspection on October 1st, 2025, you can see the condition of the property is in violation, direct violation of our code section as it deals with maintenance of building.
All right, and it looks like some of the paneling is just completely missing on top near the roof.
Yes.
All right. At this time, the city would like to introduce the 10 photographs into evidence.
Can I get a motion?
Mr. Chairman, I move we accept the 10 photographs presented by the city as evidence of the condition of the property.
A second?
Second.
Thank you. All those in favor?
Aye.
Any opposed? Thank you. And does the city have any other comments or recommendation?
Yeah, the city's recommendation is that the property owner be given 30 days to bring the property into compliance or face a fine of $100 per day thereof.
Thank you.
Question,
Yeah.
what is the use of the property currently? I mean, obviously
Is
it's
there
nothing
someone
because it's
residing there
unoccupied,
now?
but
Is-
is it a commercial property or a residential property? It's hard to tell from these photos which one it is.
Yeah, it's the property is owned by a corporation. I'm not sure of their usage of the property.
Is the zoning residential or commercial?
This is zoned.
One moment, we have our
Don't guess if you
Development
don't know.
Services Director here.
I have a question in the meantime.
Okay, go ahead.
Sorry if I missed it. Have you been in contact with the owners?
The property representative.
So not the actual owners, just someone who represents them.
Right. Again, yeah, we send a notice to the owner of record, Palm Beach County property appraiser. It goes to the owner of the property and the registered agent.
And they've responded to that in some way.
They have reached out and tried to keep the city abreast on their desire to bring the property into compliance. But as of today, the property is still in a state of non-compliance.
I have a question. On the door in the photograph, officer, I mean, I'm not sure if that's a front porch or that's living area. Were you able to inspect? Did they open the door? I mean, is that a porch door or is that the main door into the house?
Yeah, so again, I can only take photos from what can be observed from the street, so I have.
Looks like the windows are boarded up. Is that accurate?
Yeah, some of the windows in the front
So
are boarded
it's
up,
hard
some
to
are
even
not.
assess that.
Right.
Thank you.
You're welcome.
Any more discussion?
Well, let's get this other question answered. I think we have some information.
Good afternoon. Could you please state your name for the record?
Amy Alvarez,
And Ms. Alvarez, what is your position with the city?
Assistant Development Services Director.
And are you familiar with the area of 32 Salina Avenue in Delray Beach, Florida?
Yes.
And
Well-
I believe there was a question from the board as to what is the zoning district?
So the zoning district is RM. I want to be sure you're asking about the zoning district, not
Right, not
the
specific to that
use.
property, right?
Okay.
Yep.
Yep. It's RM, which is multifamily, medium density.
Thank you.
Thank you.
All right, other discussion?
I'd like to get you guys' feedback. You know, the city worker is working extremely hard. It's owned by a corporation. They're only let a representative speak to them. So they are aware of the situation. If they really wanted to come in compliance, someone who make decisions would have been in contact with them. What do you guys think about that?
I agree, I concur.
It almost seems to me like somebody owns this and they're not sure they're ever gonna rent it, or they're gonna do anything with it, and they're not, there's no incentive on their part if they're not gonna make money from it.
Yeah.
By renting it, why bother? Well, that's not the way the law is set. You wanna, doesn't matter to us whether it's in use or not, it should look nice and be safe.
That's correct.
I agree. I think 14 days might, we should get their attention, and because it's to bring them into compliance, correct?
I didn't understand what the city was asking for, Jimmy.
City recommended 30 days and then $100 a day.
So this is a maintenance of buildings violation. It depends on what they want to do to bring this into compliance. Certain things might require permits, some things may not require permits. So we're just asking for 14 days for them to properly maintain.
14 or 30.
Well,
apply
I'm
for
sorry.
permits?
I'm so sorry. No permits. It
Just-
depends. It was just
just
however they
to-
want to bring the property into compliance. I heard 14 days. My apologies. The city is recommending 30 days or $100 a day per day based on the amount of, what
Right.
we've observed. What will be reasonable in this situation?
Hey, may I comment? Jimmy, I think you're saying we want to make that a little more urgent with the 14 days, more do it now, but I think it's not feasible to get all the permits and plans in place. But I think because it's obviously a commercial property, by that I mean it's not a primary residence being rented for profit.
Correct.
So I would say, since it's a commercial venture, and it looks like the compliance date on this report was August what?
Yeah, the property was cited on July 9th. The original compliance date was August 15th of 2025.
So August 15th was the compliance date. This is later in October. So I don't think the time is going to motivate them. I think perhaps a more appropriate fineage. That's my thought. Thank you.
If I might, just two things for you to think about. One is, as tempting it is to hold them accountable for not meeting the first deadline, you are still required to give them a sufficient amount of time from your order to the compliance date so that they can comply. It is not appropriate for you to give them insufficient time so as to force them into non-compliance because it is not doable. So you always have to consider what is a reasonable amount of time, and you are certainly allowed to ask the officer in the city about what is a fair amount of time for them to go there and then reach your own judgment how to get there. But at the end of the day, you still have to, no matter what happened prior, you still have to give them enough time to comply with your order so that it is not a default by default.
I think we covered that together. Thank you, Jimmy.
Yeah.
I mean, I
Can we
think,
get a motion? Can
yeah,
I?
just looking at the photographs and the roof only, a permit is going to be required because the rules are very, very strict, and it's in terrible shape. So, I think 30 days.
All we're doing is
would
giving
be
them
the-
time
would
to
be a
come into
minimum
compliance.
of-
The
yeah,
city
minimum
For the
will
record,
judge
this
that.
board should
Yeah.
never, ever, ever make a recommendation about how they should come into compliance because then you are responsible for it. So I don't think it was your intention to give them a recommendation.
No, I was
about
going to say
it.
the 30 days is appropriate because of the fact of life of how long it takes to
Okay,
get
I
a
agree.
project like this going.
I want to make sure you're telling us we want to make sure we don't tell them how to come in compliance,
That is correct.
because that's just not our
That is not your role.
prerogative.
I mean, sometimes because we get lost in the weeds sometimes, but it's always important to remember is that there's two functions here, right? One is to listen to the facts and identify whether you believe the facts demonstrate a violation of the code as it is written, and second, to give them a compliance date that is sufficient for them to reasonably comply with. That's all. That's it.
Okay. Question. So the city does feel 30 days is sufficient time.
Yes, the city feels that 30 days is sufficient time to apply and obtain an approved permit and to make steps towards compliance.
Board members. If you,
Whoever draws this up,
let's get
Mr.
a
Chairman, I think
motion
that it should not be 100. I would recommend 250.
okay.
I agree.
250. Okay. Mr. Chairman, I would like to make a motion with respect to case number 00056. I move for finding of fact and conclusion of law that there is good notice and violation for the building maintenance exists on the property. The offending party shall correct all violations within 30 days or pay a fine of up to $250 a day per day for each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance, and if the violation is not brought into compliance, the code enforcement officer shall report back to the board. In event of non-compliance, a lien for the daily amount shall be imposed on the property.
Thank you. Do I have a second?
Second.
Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes. Before we move on to the next case, just a reminder to the audience and to the board members that cell phones should be silenced. Board members, we're here to focus on the details of the case, so I know sometimes emergencies come up and we're volunteers here, but we are here to do our jobs on behalf of the city, so thank you. Next case.
All right, next case, case number 4 on the agenda, code 2500058, property owner JoJo Realty LLC, registered agent Frank Canigla, property address 501 East Atlantic Avenue, presented by Code Officer Delinda Wachowski.
And is there anybody in the audience that is here to speak on this case? All right, go ahead.
Good afternoon. My name is Delinda Witkowski. I'm a code enforcement officer for Clean and Safe. I'm here regarding a parking lot maintenance violation located at 501 East Atlantic Avenue. On July 10th of 2025, as I was driving along, I inspected this property and I observed the parking lot required maintenance such as patching up holes, repairing concrete lids to water meters, sealing and restriping of the parking lot. This is in direct violation of our code section 4.6.9, subsection D, subsection 10, subsection B, which states that it is the owner's responsibility or operator of the specific use to ensure that the parking lots are kept in good operating conditions. such as maintaining, resurfacing, restriping surface markers, re-anchoring, or replacing loose and broken wheel stops and replacing painted signs. Therefore, a notice of violation was issued, first class and certified, and mailed out on September 16th of 2025. Certified mail was received on September 29th of 2025. Regular mail was not returned. Posted at the City Hall and hand-delivered on September 17th of 2025. A reinspection prior to hearing was conducted on September 30th of 2025. As of today, the violation continues to exist. I do have 8 photographs that I would like to introduce into evidence.
I believe no one was here for the case.
You believe someone is here for this case?
No, it's not. I think you called out to see if anyone was here for the case.
Yeah, I did. I
Okay.
did, yeah.
Just wanted to make sure. I thought I saw some movement behind me. All right, thank you. Now showing has been previously marked as City's Exhibit 1 for identification purposes. When was this photograph taken and what does it depict?
This is July 10th of 2025. It's just one of the photos of the parking lot. You can see that the handicap space is very faint, and the parking lot itself, you'll see in other pictures that there's the striping you cannot see.
And this is a fair and accurate depiction of the violation?
Yes, it is.
Thank you. City's Exhibit 2 for identification
I
purposes?
believe this is a water meter, and it's cracked and broken and obtaining water.
Well, that was on July 10th as well.
I'm sorry, yes, July 10th of 2025.
All right, City's Exhibit 3.
This is just a few potholes that need to be fixed, and this was taken on July 10th of 2025.
And then you say a few potholes. It looks like a darker area.
Throughout the parking lot, there's a
with
few
some-
potholes that need to be corrected.
All right, thank you. City's Exhibit 4,
Okay, this is another water meter that's cracked and broken that needs to be repaired.
and that was on July 10th.
Yes.
City's Exhibit 5.
Okay, this is a reinspection photo. I apologize, there was a lot of people there, so it was hard to take a good picture of the parking lot of September 30th of 2025, but obviously you can tell that nothing has been done.
So when you say nothing has been done, it looks like the parking lot still needs to be restriped?
Correct, it needs to be resealed, restriped, and fixed. All the potholes and all the water meters.
And then while you were there, did you get a good look at the entire parking lot? Not just this photograph, because I know you said something about not being able to take a great photo, but you were there and had the opportunity to observe the parking lot.
Yes, I was.
Thank you. City's Exhibit 6.
Okay, I kind of peeked underneath the car. I think by our ordinance I can do that. I can peek under the car. So I took a picture of that. There's a pothole there.
That was on September 30th.
Yes, September 30th.
City's Exhibit 7.
This is September 30th. There was also another reinspection photo. You can obviously tell that nothing has been, they haven't resealed it or restriped it. And because they need a permit for this is because when you reseal, you can't see the lines. And so they have to, the city has specifications as far as the striping and how it's done. And so that is why a permit is required.
And speaking of permit, I'm now showing you has been previously marked as City's Exhibit 8. What does this depict?
This is just one of from the EPL from our system showing that that they applied, but it's not yet completed in the system.
So they have applied for a permit?
So they have applied, but it's not approved yet, nor has the work been done. And in the narrative, I requested an approved permit and work be complete within 30 days.
Okay, thank you. At this time, the city would like to introduce the 8 photographs and screenshots into evidence.
Can I get a motion to that effect?
Make a motion. With regards to case number 25-00058, I move we admit the documents and pictures, number 8 of them, by the city into evidence as the city has the exhibits, 8 of them.
Thank you. Second?
Second.
All those in favor?
Aye.
Any opposed? Thank you.
Okay, the city recommends that 30 days to obtain an approved permit and to also complete the work, which would be restriping, resealing, fixing potholes, fixing the broken water meters, and so forth within 30 days or $100 per day thereafter for non-compliance.
All right. Anything further?
Nothing further from the city.
All right. Board members, any questions for the witness?
Is the use of this parking lot dedicated to a building where all the cars are shown in the parking lot doing using the building adjacent to the parking lot
The
only, or
usage of this
others?
parking lot is for Muscle Beach Restaurant and for Bernie's.
For information, is it just that strip or the entire parking lot they have to,
Well, it's not that big, but it's the entire parking lot.
okay, so that is the parking lot?
Correct.
Okay, thank you.
I have a question.
Yeah.
So you're stating, officer, that they have applied for a permit to fix the potholes, the water meters, the handicap spots, and anything else that you've noticed that's out of line in the photographs?
Correct.
They've applied for that?
They've applied, but the permit, I believe, is still in review, so it has not been approved.
I have empathy when a permit is in review. So, and you're saying it should come out of review within how many days?
They need to obtain it before they do the work.
How long, as a representative of the city, how long would you say it's going to take for them to come out of a permit review?
Well, technically, this, I understand your question, but this has been, this was postponed from last code board, so they've had plenty of time to do it.
I appreciate that they didn't apply timely. And I apologize if I'm being rude in any way, but if, based on prior conversation with our council, we want to make sure we offer the proper amount of time.
If they respond back and forth and they have a good permit approvals, that they gave all their paperwork and everything was correct, they should, 30 days should be enough.
Thank you.
Question.
Hey, I'm so sorry. She said it's correct. I just wanted to, because I understand your question.
I
I
hope I
understand your
wasn't being
concern.
too rude about
no,
it.
no, absolutely not. I think your question was, is this a reasonable amount of time to come into compliance? Before she finished, we do have our chief building executive here who will be, to represent permits. I mean, I hate to put him on the spot, but that is a good question, And it appears that they applied on 9/23. So.
Could you give your name for the record, please?
Steve Tobias for building.
So, Mr. Tobias, assuming that we kind of get, I hate, for lack of better words, a clean or good submittal and they respond to comments appropriately, how long does it typically take for a person to obtain a permit for resealing and restriping of a parking lot?
I don't know. That's not my department.
Oh,
but
I'm so sorry.
I'm going to say that it's usually reviewed within 10 days.
So, okay, usually. Thank you.
I do have a question.
Go ahead, Jenny.
Is there anything that the tenant is required to do right now, or are we just solely waiting on a city to review the information to release a permit?
Do you know the answer to that question, Ms. Witowski?
Well, it just it's in review, so it depends on, it could be on the city side, it could be on their side. So it could be on hold because they're not responding to responses.
Can you give us a moment to just look up the permit status? Because we can look that up in our system. One moment.
Thank you for doing that. I appreciate it.
Yeah.
Thank you.
Not sure
One
that's relevant
question
for
about
getting the
this
case decided, but-
permit data up there, 150 square feet. It's a funny number to me for a project as described in the photographs.
Give us 1 second.
Yeah.
Well, for discussion, Mr. Chairman, the reason why I ask is because if the tenant has nothing to do and they're waiting for the city to respond, and they take another 30 days, how can they come in compliance? So that's the reason why I'm asking is who's
Mr. Chairman, I don't think they should do anything that's not permitted. It could be wrong.
correct.
You spend money and it's wrong.
They're waiting to hear back from, that's my question, who are we waiting on? Now, if they're not responding to comments, then that's different.
I think we're being very fair in asking the question.
So 30 feet wide by 50 feet long is 150 square feet. That's I think, about the size of that lot.
Yeah, that's what
I mean, it looks bigger because it's a wide angle lens there, but I think if you actually went and looked at that lot, you'd find it's not as big as it looks in some of those pictures.
Just a reminder, we're still in session, so anything you say should be said into the microphone and is open to public record.
That was the question.
No math questions, please.
I just consulted with our staff members. It's only been with the city for 2 days.
Okay.
So 30 days, do you recommend 30 days is sufficient amount of time?
To receive an approved permit?
Yes, ma'am.
Yes,
Well, I mean, we're looking for compliance here, but yes, so,
correct. But I think he asked me about the permit process, but yes, to achieve compliance, yes.
motion?
Mr. Chairman, I'd like to make a motion with respect to the case number 25, thank you, 000058. I move for a finding of fact and a conclusion of law that there is good notice in the violations that are shown in the photographs, including the water meter damage, the handicap parking painting, and the overall condition of the parking lot still exist on that property. The offending property shall correct all the violations by obtaining permits within 30 days or pay a fine of $100 per day each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board. And in the event of non-compliance, a lien for the daily amount shall be imposed on the property.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes. All right, next case.
Next case, case number 5 on the agenda, code 25-000060, property owner Pat's Management, Inc., registered agent Patel Rashishwar, property address 337 Northeast 2nd Ave, presented by Code Officer Delinda Wachowski.
And is anyone present in the audience for this particular case? Okay, come on up to this microphone over here. And when you get here, just give us your name and address for the record, please.
Business address or my home address?
Either way. Just need
Okay, Rajeshwar N. Patel, President Owner of Pets Management Inc., 337 Northeast 2nd Avenue, Delray Beach, Florida, since 1987, same place.
Thank you. Okay, Ms. Warren?
You may proceed. Thank you.
Okay, good afternoon. My name is Code Enforcement Officer Delinda Witkowski. I am here regarding a parking lot maintenance violation located at 337 Northeast 2nd Avenue. On July 12th of 2025, I inspected the property where I observed parking lot that required maintenance, such as patching of holes, sealing, and restriping the parking spaces, plus handicap space that must be executed in accordance to the ordinance. This is in direct violation of Code Section 4.6.9, subsection D, subsection 10, subsection B, which states that it is the responsibility of the owner or the operator of the specific use to ensure that the parking facilities are kept in good condition. Therefore, a notice of violation was issued via first class and certified mail on September 15th of 2025. The certified mail was not received, the regular mail was not returned. Posted at the property and at City Hall on September 17th of 2025. A re-inspection prior to hearing was conducted on September 30th of 2025. As of today, the violation continues to exist. I do have 5 photographs that I would like to introduce into evidence on this case.
Thank you. I'm not sure it's been previously marked as City's Exhibit 1 for identification purposes. When was this photograph taken, and could you describe the violation?
This is taken on July 12th of 2025. The parking lot has actually, you cannot see the striping hardly whatsoever.
So there's no lines?
No lines for the handicap and for the regular parking.
Okay, thank you. City's Exhibit 2?
Okay, so here's handicap. As you can tell, you can't,
Very faint, if any.
yeah, very faint, but hardly nothing at all. So it just needs to be resealed and restriped.
City's Exhibit 3?
This is the re-inspection prior to hearing that continues to be non-compliant, which was taken on September 30th of 2025, where nothing has been done. The parking lot continues to be unstriped and unsealed.
Thank you. City's Exhibit 4?
So there, you can tell there's there's a couple little potholes, but nothing severe.
But the striping is still missing.
The striping is necessary, yes.
Thank you. City's Exhibit 5.
Okay, so as you can tell here, he has, on his behalf, he has pulled a permit, and I think it's been like that for a little while, but it's been in review, so I'm not sure if it's on behalf of his comments that he has not commented back, or for the city. But he needs approved, on the narrative it says that he needs to apply and obtain approved permit and do the work as well.
So as of today, there's no approved permit, and there was no approved permit prior to the compliance date, correct?
Correct.
Thank you.
Okay, can we get a motion to accept these exhibits?
I make a motion, Mr. Chairman, that we accept the exhibits 1 through 5 as presented by the city.
Second.
Second.
Thank you. All those in favor?
Aye.
Any opposed? Okay, those documents have been accepted as exhibits 1 through 5.
I believe the
Yes, you have the opportunity now to question the witness about what she's provided, the statement she's provided, or about any of the evidence she's presented, and provide any rebuttal testimony.
Yes, because a lot of good thing is missing out of this. So here is the deal. I'm there since 1988, first time coming here, first time. Okay, so first thing is I was away, 20th July I came back. There was a notice from the officer there. Mm-hmm. I acted on it straight away. I came here to city. No, she put it with that you can't do it. Anything, you have to go to city hall to get a permit. Mm-hmm. I took out permitting everything over 6 years ago, but I did a proper parking lot. I did it with the filling and everything, sealing, striping, but the business is there since 72. I own it from 87. When I came to the city hall here with the saying, hey, this is approved permit, but it's 6 years ago. Am I allowed to do it straight away, sealing and that? I take a responsibility. But the way it's done, that I've ignored it for 2.5 months. I've been so many times, believe me. So this I'm saying, is there a you are recommending what the fines and everything. Is there any way you recommend CD what to do? So when I came, they could not answer me one. They did not know whether first time, whether I need a permit from that drawing, which I already had it. I can go ahead and seal it, do the permit, not myself, from the company. The person who did it, the company who did it, All County, legit company, 6 years ago. So straight away, the person at the counter did not know the answer. She went to ask somebody. Second person did not answer. And then they came and said, no, you need a permit. Now I'm looking to get a permit. Mm-hmm. So suddenly, listen to me, 6 years ago, I paid $4,000, including refilling. Now everybody wants $4,000 and $5,000 as long as the permit name comes in. Okay? So I said I have to get an extra quote. I ended up with getting 3 quotes. They were all around $3,000. So I selected the one. I paid them $2,900. I got everything. And another $900 for permitting. They applied. Mm-hmm. While I was away 2 weeks, as soon as I came back again. The permit is not issued.
So can
permit is there.
Oh, so sorry. Just for clarification, we just noticed a error. This is not the permit correct screen, so we ask that you withdraw this exhibit from Evidence Exhibit 5. For clarification, no permit has been approved. This is the incorrect permit number. So if you see the permit number with the 4
it's the wrong address.
Wrong address.
Right. This is the wrong.
Wrong slide for the wrong that's
slide.
For the prior
case. That's what I'm saying. That's for the prior case, right?
Mr. Chairman, at this time, I'd like to amend my previous motion to remove Exhibit 5 and only accept Exhibits 1 through 4, which were photographs that were admitted by the city into evidence.
Second. Thank you.
And if I can just, I'm so sorry.
Yeah, let's, all those in favor of amending the list of exhibits?
Aye.
Aye.
Thank you. Any opposed? Okay, so exhibits 1 through 4 accepted, exhibit 5 is ignored.
Yes, I just want to get some quick testimony, if you may, or
yes.
If you want to let him finish his portion of his case, and then we can come back on rebuttal.
I think they have some more information that's relevant to the standing of your permit, so can we continue, and then we'll come back to you and you can have a chance to respond, okay?
Yes, but can I ask one question to her?
Yes.
I know her now.
Well, I'm not a witness, I'm the attorney.
She's acts as the city's attorney, so she presents the case
Okay,
to
so
us.
you
That's
are city
her role.
attorney.
Correct,
Okay.
I was gonna call the witness.
Yes.
Okay.
Okay, so
Just go to the microphone. Good afternoon. Could you please state your name for the record?
Code Officer Latoya Thompson.
Are you currently employed with the city?
Yes, ma'am.
And are you familiar with city records as it relates to permits?
Just right now, as
Well,
we're
just
speaking-
generally, in general.
Yes,
You
yes.
know how to look for permits in the city.
Yes, absolutely.
And did you happen to look into the city's official records regarding any permits related to the property located at 337 Northeast 2nd Avenue?
Yes, ma'am.
And were you able to find any permits for any parking lot striping or resurfacing?
There is one, and it's on hold.
It's on hold?
Yes.
Okay. So it's currently still in review?
Yes, ma'am.
Okay, thank you. You just wanted to clarify. Okay.
For point information,
and do we have a reason for that hold? Do we know the reason for that hold?
One moment.
May I allow to speak to you?
Yes.
sir?
I think we're in the middle of she's coming up right now. Did you want us to answer that question first? Or?
Yeah, let's get the answer to the question, and then you can speak to me, or you can question the witness further.
Thank you. Thank you. We now have Miss Amy Alvarez, Assistant Director of Development Services. Ms. Alvarez, there was a question asked regarding the permit relating to the property located at 337 Northeast 2nd Avenue. Did you have the opportunity to look into the city's official records regarding permitting?
Yeah, so according to Project Docs, it looks like the review is complete. So it's been 7 hours, and so we're just
So it's just
finishing
waiting the city's final
for
sign
issuance.
off.
Yep.
Okay.
What, 7 hours ago?
Yes.
So why this was not postponed? If CTA just completed 7
Sir.
hours ago?
Because
Sir,
there are
we
multiple,
did not-
sir, there's multiple departments in the city, and they have to communicate with each other, so the code enforcement department doesn't necessarily know what the city building department is doing on a permit. All they know is that when they last checked, that was not the case.
And it has
It
not.
sounds like it's in progress.
Yes.
And so hopefully we'll get this resolved. So
you are Mr. Cohen, yeah?
yeah, so as I understand what you said so far, and then I'll let you continue, you were away, you came back, you started the process, you got a quote, the company that's doing the quote should be pulling the permit. It sounds like they've started that process, and now we're just waiting for that to move ahead.
My question to you,
Yes.
and if this committee can recommend them, say if something like this, I wanted to comply a month ago.
Mm-hmm.
Why? I'm not building a property there, like Avenue, anywhere. I am just sealing my parking lot, putting it looks so bad on me here when she present. Okay, look at this handicap parking. I collect money for handicapped people and service. Really, my blood pressure has gone up already. The thing is, it's so bad putting it in me in a position that is my fault when I want to do it 2 months ago, this thing. They don't give a permit. I call every week this guy, Jason from this company, all this thing. I paid them even. And they have a right to come and say against me, look at I have not done. I came here, 2 people in a CD could not answer me. Third one say, no, you need a permit. I came with all the paperwork I did. I said, can I seal it at least and put a stripe? And then you do whatever, I'll pay the fine. I'll pay the thing. No, apply for a permit.
I understand.
So this I'm
Ms.
saying,
Warren.
why they cannot do it that in 3 working days? I'm not building a property.
I
This
understand
should
the.
be city attorney.
Could
right
you please
now.
not direct?
Sir,
I
sir,
said- no,
sir,
believe
you
me,
can't
my
talk,
son is attorney
sir,
as well. I'm just
sir.
saying that this should be done in 3 days, sir. 72 hours.
Sir,
This
you
should
have
been
to,
done
you
in
have to
72
direct your
hours.
comments to me unless you directly allow you, unless I
yes.
allow you to directly.
Please, sorry about
question the
that.
witness.
I'm just saying that they
Yes.
should have done only in 72 hours.
I understand you're frustrated. It sounds like we can get a resolution here where we will give you sufficient time to get it finished. It sounds like the process is underway. So does the city want to continue with the recommendation of 30 days and $100 a day if it's not compliance after that period?
Correct. It sounds like it's in the progress. It's looks like it's finalizing under staff review. Just a reminder, the compliance date was previously.
It
was a month ago, right? It wasn't today anyway. So
It was August 25th.
so we're just longer than that, so we're just asking for the 30 days,
30
and then
days.
once we,
Mr.
it's
Chairman,
resolved.
clarify for me.
Yes.
Compliance means permit is obtained.
The compliance means compliance. The city will assess whether what
Could
compliance
I get a
is.
definition?
Well, in the violation, it says obtain a permit, so.
Thank you.
It's
Thank
obtain
you.
a permit and complete the work.
Discussion.
Thank you.
Can we have discussion?
Oh, and complete the work?
And complete the work.
So, Mr. Chairman, I have the question of the witness through you.
Just for clarification, because this comes up every time, and so compliance means that the property is no longer in violation of the code section that's at issue. That is always what compliance means.
Okay.
Yeah.
So he has a quote in his hand. Is he telling us through his testimony, Mr. Chairman, that that's enough time? That's my question.
Further discussion. Seems like the permit is on its way. He does have a professional company, and we can tell by the passion of the tenant, he would like to get this resolved. Could we postpone this until next time? Because
We can certainly do that.
Can we do that? Because it looks like he is trying to come in compliance. The city is going through the process. You just need to be a little patient. So can we just postpone it and then?
Would you like to make a motion?
Mr. Chairman, I'd like to make a motion that we postpone case number 00060 until the next code enforcement board meeting.
Second?
Aye. Second.
Okay, the motion is to postpone this case until the future code enforcement board meeting. And any discussion on that motion? Hearing none. All those in favor?
Aye.
Any opposed? Sir, we've postponed your case. If you get it concluded sufficiently with the city between now and the next code enforcement meeting, then you will not have to come back here, okay? If it's not concluded to the city's satisfaction, then they will tell you that you need to come back at the next
When is
meeting.
the next meeting, by the way, here?
It is typically the second Thursday of the month, so that would be the
I
second
think it's
Thursday
the 10th of November. The 10th of November.
No, it will be done. So next procedure is I have to go, they'll write to me, they'll come and collect it, permit. If my guy doesn't go, I want to go and collect it.
I'll go and speak with you at your location, okay?
I'm not sure if it's the 10th, that's a Monday.
It's not the 10th,
Well,
yeah.
you'll be notified,
The
we'll
ninth.
notify you.
It's in the beginning of
It
November.
might be that week, I believe it's the 13th, but he will be notified. Thank you.
I want to comply with everything.
And we appreciate
do.
that.
Just
Thank
to
you,
let
sir.
know, this is the first time I done many times, every 2 years, city get parking. First time I apply for the permit. So I think I owe a lot of money to city for permitting.
All right, thank you.
Thank you,
Thank
sir.
you.
We appreciate you coming here today, too. I know it's frustrating. Okay, next case.
Next case, case number 6 on the agenda, code 25-000094, property owner Malarkey Investments LLC. Property address 638 Southwest 7th Ave, presented by Code Officer Reggie Williams.
Is there anybody present in the audience? Why don't you come up to the microphone here, give your name and address for the record?
Carson Malarkey. I'm currently at 916 Southeast 5th Ave, Delray.
And your relationship to the property? You're the owner, or?
Yeah, I own 90% of the LLC that owns the company.
Okay, thank you.
Or owns the property.
Ms. Warren, if you would.
Yes, thank you. Ms. Matuski, if you can I'm sorry, Mr. Williams. Please proceed.
Good afternoon. My name is Code Enforcement Officer Reggie Williams. I am here regarding work without permit violation located at 638 Southwest 7th Ave. On July 18, 2025, I inspected the property in response to a complaint via email from the building department. It was reported a fence was installed without an approved permit, which is in violation of Code Section 2.4.13, subsection B, which states that building permit is required for all items as set forth in the current Florida Building Code in Chapter 7 of these land development regulations as amended. A building permit shall be sought via application through the Development Services Department. A work without permit violation was issued on July 30th, 2025. The violation was mailed first class and certified mail on September 16th, 2025. The compliance date was required by August 14th, 2025. On August 15th, 2025, I re-inspected the property. Subsequently, a notice of formal hearing was issued via first class and certified mail on September 16th, 2025. A certified confirmation of receipt was not received. Regular mail was not returned. posted at the property and at City Hall on September 17th, 2025. A reinspection prior to hearing was conducted on October 3rd, 2025. As of the last reinspection on October 3rd, 2025, the violation still exists. I have 6 photographs taken of the property in question. I would like to introduce these photographs as evidence. I have had contact with the property owner.
Thank you. I'm now showing has been previously marked as City's Exhibit 1 for identification purposes. What does this photograph depict and when was it taken?
This was taken on July 18th, 2025, and this is behind the property in the alleyway that shows the fence that was put up.
And then you say fence is kind of like the tan fence.
The brand new looking tan fence.
Thank you.
yes.
City's Exhibit 2 for identification purposes.
This was taken July 18th, 2025, and the tan part of the fence is part of that was put up without a permit in front of the property.
Okay, thank you. City's Exhibit 3.
This was my reinspection on October 3rd, 2025, and the tan fence was still at the property.
Okay, and no permit.
No
as of
permit,
that
no.
date. Okay, thank you. City's Exhibit 4,
This is the front of the property showing the tan fence that's located in the front.
and that's at October 3rd.
October 3rd, 2025.
City's Exhibit 5.
This was a Google Maps that I pulled on July 18th that shows the property of April 2024, where you can see on the right side of the property, there was no fence, and behind the property, in the alleyway, there was no fence constructed.
All right, so now I went from no fence to new fence.
Yeah.
No permit.
Yes.
And then City's Exhibit 6.
This shows that he.
This is the correct.
No.
Oh,
It's
you know,
not- yeah.
maybe they're mixed up. So
They're-
you're correct. I see the incorrect address. Did
Yeah,
you just give me one moment? Maybe there's a trend here. Maybe it's the next one.
But I looked it up.
Yeah, just tell us what you were able
I looked
to
it up
find.
10 minutes ago, and it's still on hold.
On hold, as it's still
The
in there?
status is still on hold. Yes,
Okay.
he applied for the permit July 31st, 2025, and it's still on hold at this moment.
Mr. Chairman, can I use the restroom?
Well, yeah. Oh,
Yes. Please note that one of the board members is stepping down. We maintain quorum because we have
Thank
sufficient
you.
board members.
Give us 1 second. We can, if you're, I don't know, someone asked or.
Well, I spoke with the property owner, and he informed me that he was trying to get a surveyor to come out to get the process started.
All right, so it's on hold due to a survey issue.
Yeah.
Okay, thank
Yes.
you.
Okay. You have opportunity to question the witness and also to provide any rebuttal testimony to what we've heard so far. But first, we need to admit these exhibits
Yes,
into evidence.
if we can move the 5 exhibits into evidence.
Okay.
I'll make the motion.
Thank you.
Make the motion on case number 25-00094 to admit into evidence the 5 exhibits on behalf of the city regarding the Clay case that we're going to discuss.
May I make a correction? It's case number code 25000094.
Oh, I apologize.
Extra zero in there, yes.
So it's code 25-000094.
Thank you.
It's like a
Second?
number.
Second?
Second.
Thank you. All those in favor?
Aye.
Aye.
Any opposed? Hearing none, the exhibits are admitted into evidence. So now you have the opportunity to question the witness and to provide any rebuttal testimony.
Gotcha. What's up, Reggie?
How's it going?
I did finally get a surveyor out there. I got Pinnell Surveyor out there. I received the survey on Monday. I didn't get a chance to look at it until this morning. So I just need to resubmit, and then I don't really know the process of getting a fence that's already built permitted. I figured since it was already built, they would just come out and inspect it, and I wouldn't really need to submit anything. But I did get it surveyed, and so I just need more time to resubmit.
Well, I think Reggie can tell you a little bit more about the process. I don't think it's quite that simple.
Yeah, I know.
But
I realize that.
what the city's going to be looking for is going to be compliance, which is getting that permit in since the fence is up, probably in this case. Does the city have a recommendation?
The city suggests that the property owner be granted 30 days to obtain an approved permit or face a fine of $50 per day until the violation is corrected.
And you think you can get that permit done within 30 days?
Yes.
Any questions from the board?
No.
We have the motion.
Mr. Chair, real quick, just for the record to be noted that Mr. Canton arrived back to the dais.
Thank you. I appreciate that.
Are we ready for the motion?
Yes.
Mr. Chairman, I would like to make a motion with respect to case number 25000094. I move for a finding of fact and the conclusion of law that there is good notice based on the officer's testimony and the photographic evidence that fences are in place without a permit that exists on the property. The offending party shall correct all violations by obtaining a permit within 30 days or pay a fine of $50 per day each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board, and in the event of non-compliance, a lien for the daily amount shall be imposed on the property.
I have a question. If I pursue getting the permit and like come across hiccups and I'm not able to get it done by within the 30 days, but progress is made, will the fine still be applied?
I can't speak to whether the city will bring that forward to the code enforcement board. If they do bring it to the code enforcement board, then yes. But typically, I think the city wants to see compliance. So if they see that you're making progress,
okay.
So may I just add a clarification to that, since you mentioned the city? Once the board has the order, then we can't really do anything outside of the order. So then, we just encourage him to contact the city, and if we need to get this on for an agenda item to get an extension, then we would do that. That's how we would have to proceed.
So just for clarification, also to the board, it's a two-part process, right? So this is a violation hearing, right? And if the city believes that you did not comply with the order of the board, they bring it back to the board for an assessment of fine. And at which point, you could argue that you either did or there was an impossibility, or you could make an argument there. Though I will say, typically, if you go to the city with legitimate, they might join you in extending that. But it is important to know that the board's order is the board's order.
Okay.
Okay. Do I have a second to that motion?
Second.
All those in favor?
Aye.
Any opposed? Hearing none, motion passes. Thank you.
Thank you.
Appreciate you being here. Next case.
Next case, case number 7 on the agenda, code 25-000102. Property owner Ellen Ryan, property address 2496 Douglas Avenue, presented by Code Officer Latoya Thompson.
And are you Ms. Ryan?
Yes, I am.
Okay, well, welcome. And is that your address, the 2496 Douglas Avenue? Okay, thank you.
Mr. Chair, I don't get a welcome.
Well, welcome. I think we've seen you up here before.
You have. I'm back.
But I didn't welcome you then, so glad to see that.
Good afternoon. My name is Code Officer Latoya Thompson with the City of Delray Beach Code Enforcement. I'm here regarding a damaged roof / maintenance of building violation located at 2496 Douglas Avenue, Delray Beach. On July 22nd, 2025, I inspected the property where I observed the roof was damaged. After speaking with the building official, it was determined that a permit would be needed for repairs. This violations which is in violation of the City of Delray Beach Land Development Regulation Code, Section 7.8.3, maintenance of building or structure required, which states all building or structure, both existing and new, and all parts thereof, including all materials, fixtures, or appliances installed therein, shall be maintained in a safe, secure, and sanitary condition. A general violation / hearing notice was issued July 22nd, 2025. The violation was mailed first class and certified mail July 31st, 2025. Compliance was required August 22nd, 2025. Certified confirmation receipt was received September 15th, 2025. Regular mail was not returned. Posted to property and City Hall July 31st and August 1st of 2025. A reinspection prior to hearing, which was the hearing that got canceled September 11th, was conducted September 8th, 2025. As of the last reinspection on October 1st, the violation still exists. I have 3 photos taken of the property in question. I would like to introduce these into evidence.
Thank you.
And I have been in contact with Mrs. Ryan, who's the property owner.
All right, and now showing you it's been previously marked as City's Exhibit 1 for identification purposes. When was this photograph taken?
This photograph was taken July 22nd, 2025.
And could you describe the issues? I know you said something about a permit being required and the roof. So if you can describe the violation here.
So history on this, last year around this time, it was a hurricane, a tree fell on it, and we asked them to remove the tree. The tree was removed, but the roof remained the same. It was a citizen complaint that came in from a neighbor, and I inspected the property and issued a violation to the property owner.
So just to describe roof damage.
Roof damage.
Okay, thank you. City's Exhibit 2
The roof was repaired.
on September 8th.
2025.
Repairs were made, but we don't know if it hasn't been approved for a permit, correct?
Right, no permit was on file.
All right, and now showing has been previously marked as City's Exhibit 3 for identification purposes.
In EPL, this is it's a all permit. You can search the address, and it shows that no permit was applied at the time.
Let me just make sure that's the correct address, 2496.
Yes, ma'am.
All right. At this time, the city would like to introduce the 3 exhibits into evidence.
Thank you. Can I have a motion to that effect?
Mr. Chairman, I move that we accept the photographs 1 through 2 and Exhibit 3, the list of permits as presented by the city.
Second?
Second.
All those in favor?
Aye.
Any opposed? Motion passes. Thank you for coming in. You have an opportunity to ask any questions of the witness and also to provide any rebuttal testimony.
Okay, well, I've learned a lot through this process, having a tree fall on the roof, and it took a long time to get it repaired. When I received the last notice in July, I guess, right? The date escapes me. But, I was desperate to get it repaired. And so Dynasty Roof, they were able to do it over the weekend. And I figured I would probably need a permit eventually. I did call the office to inquire about information, but I didn't follow up on it. But you came by and saw that it was repaired. And so then the process of trying to find the get the permit started. Now, I've been in contact with Andre Diaz, who is an engineer in Miami, and he wants to know, because I need another engineer, right?
You need an engineer letter that states that it was built back to specs without, because we can inspect it.
What do we, okay, so what, I guess what happens now? I've got Andre Diaz. He wanted to know, first of all, the building permit, section frame or building repair, are the repairs incidental to the root, you know what I'm saying?
So it sounds like you're in the process of trying to get your engineer to provide the documents that you need in order to get the permit.
Right, and he wanted me to ask you this question exactly.
Well, that question, of course, won't be for the board. That would be for the building department. But the code enforcement officer can help walk you through that process and tell you who to talk to get those questions answered.
Okay.
What we're doing today is just because you didn't get that permit done and that citation was made, we're assessing whether or not we should give you a certain period of time to get that permit completed and get the inspection done if necessary. And if not, then we would have to assess fines. Mm-hmm. So if I can, let me ask the city if they have a recommendation for the period of time for completion of this, knowing what you know.
I do. 30 days to apply and obtain all approved permits, which should include the engineering letter stating and confirming that the roof was built back to the Florida Building Codes standards and inspected, or a fine of $250 a day thereof.
Thank you. And so what they're saying is that they're proposing that we give you 30 days to get that process completed. Otherwise, that fines would be assessed. Do you think 30 days will be sufficient for you to get that done?
I hope. I'll call Mr. Diaz this afternoon and see when he can
And I would
I
say
mean,
definitely talk
first
with
the-
Ms. Thompson. She can help walk through that
First
process
the
of what
permit.
exactly
I have-
they need. But we don't need to do that in front of the
Okay.
board.
All right.
So,
Yes, we'll
So
talk.
I got a question
Yes.
about the engineering letter. I had to have an engineering letter for my own roof. So you're saying you've already contacted him? How long did he say it'll take to get the letter?
He just told me what to ask you here. He thought that I could ask, I mean, I guess I can ask the
After,
people that are
yes.
gonna give me the permit. And I didn't ask him how long it would take.
Thank you.
Yeah,
I have a question.
yes.
For the code officer. Was there any contact communication made to the property owner before, and was she instructed that she needed a roof before this was done?
Yes, I stated that we talked. It's in the notice, and we also talked after the fact that the roof was fixed. When I saw that it was fixed and no permit, then we started talking regarding, and I explained to her what she needed to get.
So I'm sorry if I missed that. So you did give her proper instructions. She needed a permit before the work was done.
Yep, that's in the notice. And then after it was fixed, repaired, correction, then we spoke again, and I told her what she needed to be done because the inspectors can inspect it. We would have to tear the roof up.
Gotcha. Thank you for that.
Any other questions? Someone want to make a motion? Any conversation about the $250 a day fine? Is that?
Do you think that's fair?
Mr. Chair, I'd like to make a motion with respect to case 2025. I lose the numbers that fast. Come on. 11.
000.
Need my glasses. 102. Thank you. Okay.
Just for clarification for the record, please repeat it.
2025 000102.
Thank you.
I find for a finding of fact and a conclusion of law that there is good notice and that the violations of repairing the damaged roof due to tree damage without a permit is a violation that exists on the property. The offending party shall correct all violations within 30 days or pay a fine of up to $250 per day for each day thereafter for noncompliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board, and in the event of noncompliance, a lien for the daily amount shall be imposed on the property.
Do I have a second?
Second.
Any discussion of the motion?
Could I ask a discussion?
Sure.
This is a private residence. I mean, I think $100 a day seems appropriate. Is there a reason why we're going up to $250?
I think that was the city's recommendation.
That was the city's
can we have the
recommendation.
citywide?
Recommendation.
Yeah.
Okay, thank you.
It is, the city can recommend anything the city wants to recommend, but it is ultimately your decision.
Right.
For discussion, you have a better amount?
I feel like in this case, since the testimony is she's consulted an engineer, if she doesn't come in compliance within 30 days, perhaps we could amend it to $100 a day thereafter.
if the guy can't get it done.
I mean,
I'm open for discussion.
Do you, would you be willing to accept an amendment to your motion to,
I would have no objection. I was going with the city's recommendation. I wasn't, maybe there's some situations that we don't quite understand why it needs to be that high, but certainly I could agree with anything from $100 on up to $250. If anybody got any other thoughts of what would be appropriate based on what we know about it?
so Steve, would you like to make a motion to amend the motion that's on the floor?
I'd like to make a motion to amend Mr. Cohen's motion that the fine, in fact, be $100 per day after 30 days. Thank you.
Okay.
All right.
And-
No objection for me.
And I think with a friendly amendment with no objection from the original motion, we don't need a second,
You
for
can
that.
just
We
accept the change by acclamation.
Say again?
You can accept the change by acclamation, which essentially, does everyone agree?
Does everyone agree with that change?
Yes.
Yes.
All right, and on the original motion, now amended to $100 per day, so 30 days with, subsequent to that, $100 per day. All those in favor?
Aye.
Any opposed? Okay. So just with the previous case, you now have 30 days, work with the city to try to get that permit completed, work with your engineer, et cetera. If you are not able to do so, then the city has the right to bring that back to us, begin the process of fining you, okay?
Okay.
Thank you, Mr. Chairman.
Thank you. All right, next case.
Next case, case number 8 on your agenda, code 25-000126, property owner Del Muda LLC, registered agent Richard Critchfield. Property address 28 Salina Avenue, presented by Code Officer James Easley.
Okay, and is there someone here on this particular case? Anybody present wishing to speak on this case? Seeing or hearing none? Go ahead.
Good afternoon, Code Board. My name is James Easley, Code Enforcement Officer in the Clean and Safe Unit. I'm here regarding a violation, case number 25-000126, a maintenance of building violation located at 28 Salina Avenue. On August 4th, 2025, while patrolling the area, I observed a property in need of building maintenance. The property owner was asked to consult with the building department to see if permits are required for any of the repairs. If a permit is needed, the owner is required to apply and obtain an approved permit to repair or replace the missing or damaged roof tiles and repair or replace the broken or rusted drip edge. The observed condition of the property constitutes a violation of Code Section 7.8.3, Maintenance of Buildings, which states that all buildings or structures, both existing and new, and all parts thereof shall be maintained in a safe, secure, and sanitary condition. Therefore, on August 5th, 2025, this case was established. Notice of violation and notice of hearing was mailed by first class and certified mail on August 11th, 2025. The green card was returned on August 28th, 2025. The notice was also posted at the property on August 11th, 2025. The compliance date was required by September 10th, 2025. On both September 10th and 11th of 2025, I re-inspected the property and observed that the property was still not in compliance. On October 1st, I conducted a re-inspection and observed that the violations still exist. I have had contact with the property representative, and I have 10 photos taken of the property in question to be entered into evidence.
Thank you. I'm now showing you, as been previously marked as City's Exhibit 1, that was taken on August 4th. Could you please describe the violation in the photograph?
Yes, August 4th, 2025, I was at the property where I observed the condition of the roof and the drip edge in a state of disrepair, and is a violation of our section code that deals with building maintenance.
City's Exhibit 2.
It's a close-up on August 4th of the drip edge and the roof at 28 Salina Avenue.
City's Exhibit 3, and I'm sorry, that was also taken on August 4th, correct? And then City's Exhibit 3 on August 4th?
Yes, again, another portion of the property where you can see the rusted drip edge hanging from the property and the condition of the roof.
Thank you. City's Exhibit 4?
Went back on September 5th, 2025, 28 Salina Avenue. You can see the condition of the drip edge and the condition of the roof still in violation of maintenance of building.
City's Exhibit 5?
Again, it's the same property on September 5th, 2025. You can see the rusted condition of the drip edge and the condition of the roof located at this property.
City's Exhibit 6?
Again, September 5th, 2025, you can see the condition of the drip edge, the condition of the roof still in a state of disrepair in violation of our section code that deals with building maintenance.
And it looks like it's like, you said the drip edge and the roof tiles, correct?
Yes.
City's Exhibit 7?
Yes, another angle of portion of the property on September 5th. You can see the rusted drip edge and the deteriorating condition of the roof.
City's Exhibit 8?
I went back to re-inspect the property on October 1st. You can still see that the property is in a state of disrepair in violation of the city section code.
City Exhibit 9.
Again, on October 1st, you can still see the condition of the property in a state of disrepair, the condition of the drip edge, and the condition of the roof at this property in direct violation of the section code.
And specifically in this photo on the left side of the photograph, there's something hanging from the drip, you said the edge?
Yes, you can see it's completely rusted out. It has no way to hold on to the edge of the property. And again, you can see it's in a state of disrepair in direct violation of the code section.
And again, that was in City's Exhibit 10 taken on October 1st, correct?
Yes, it was.
At this time, the city would like to introduce the 10 exhibits.
Can I ask a question first? Would you show the number 1? It doesn't look to me like it says 28 Salina Avenue.
Yeah, it's like the properties are right next to each other, and so the time stamp, the date stamp, and the location. I'm standing in between two properties.
You're
so that's not something you wrote. Yeah. That's like a technical.
Right. It's the technology.
The system puts it in automatic.
Right.
But all right. Just want to make sure that it was.
But let me ask you a clear cleanup question. These exhibits, 10, are they a fair and accurate representation of the violation that occurred at 28 Salina Avenue of the home?
Yes, exhibits 1 through 10 are the exact representation and depiction of what I observed in the field.
Thank you so much. You're welcome.
Good question. Thank you.
Good catch. Thank you.
Motion?
I make a motion we accept the photographic exhibits 1 through 10 as presented by the code officer in this case.
Second.
All those in favor?
Aye.
Any opposed? Motion passes. Thank you.
I do have a question.
Does the city have a recommendation?
Yes, the city recommends that the property owner be given 30 days to bring the property into compliance or face a fine of $100 per day until the violation is corrected.
Okay. Given the condition of the property, do you believe that is a reasonable amount of time to achieve this?
Yes.
So I have 2 questions.
Okay.
Were there any contact with the homeowner, the direct homeowner?
No, I've been in contact with a representative of the property who has been in contact with the city to try to keep the city abreast of their pending actions on the property.
Second question. So it's reasonable they're going to need to obtain a permit and replace a roof?
Yeah, it is required. Yes, sir.
So is 30 days enough time to do all that? Or is it bringing the clients getting the permit?
Yeah, that would be as part of our recommendation. The first step is to consult with the building department, apply and obtain an approved permit.
Just to make sure I understand, they need to consult with the city, get a permit, and get a roof done.
I think he said approved permit.
Approved permit.
Correct.
Right. So speak to the city, get approved permit, and get the work done.
Well, he just said approved permit.
Oh, so approved permit.
Correct. So we feel that it's reasonable to get an approved permit for this within 30 days, if needed, after they consult with the city.
Thank you.
Mr. Chairman? Yes. Gathering by listening to the testimony, it sounds to me like this is an investment property with an absentee owner.
I don't think we want to make any assessments about the nature of the property.
It bothers me when there's a rental property that's in serious disrepair. And the reason for my comment is, and I do think it's appropriate, since that's the situation, where someone else is subject to this, I think that a $100 fine doesn't sound adequate to me if it doesn't come into compliance on time.
If I might, can I just,
Yes,
so
please.
While it is okay and appropriate for you to consider the effect of a violation on a neighbor or neighborhood
Yes.
in assessing the severity of the violation, that is perfectly okay. It is not okay to treat different members of the city differently based upon their ownership status. Everyone should be treated the same.
Okay. Well, I will also look at that and say that's quite a hazard. We're still in hurricane season. I think $100 is too light. If anyone agrees with me, suggest a number. If not, I'll just stay with the city's recommendation.
Oh, I like to ask a question. How long have you been trying to get in contact with the, do you feel like the owners are making an adequate attempt to address the situation? Because if they're trying, I don't want to penalize them, but if they're just blowing, because he's doing an excellent job trying to rectify this, but if they're not complying to you, then we do need to, because we want to get in compliance, but if they're not making an attempt to work with you to bring this to compliance, then I do agree with my colleague.
Well, the condition of the drip edge and the roof did not get that way overnight. I cited the property on August the 4th. The compliance date was September 10th. And to date, the property still is in violation of the section code.
So we can confirm they're not making an attempt to bring this into compliance at this time.
Yeah, since this property was cited to today, no progress has been made on this property.
For discussion, I agree. $100 a day is not adequate.
I guess my
Make
other
a motion
question
with a proposal then.
You've contacted the owner. It's not clear to me from what we see here that you've contacted the owner. It looks to me like we've contacted a registered agent, understand that, but that I agree with the situation. It's a very weak position to say, well, we've talked to the registered agent, and you know, that is that just the owner? Is the owner really is to do that? Is the owner facing something?
Yeah, the notice.
May I just say something? I just want to make sure that we're sticking to what Chapter 162 says and what the city's roles and responsibilities are.
Mm-hmm.
Our cities are, if we find a violation on the property that's outside of our code, we properly cite the address listed on the property appraiser's address. The onus is on the property owner to try to bring the property into compliance. It is not the city's responsibility to try to, you know, I don't, for lack of better words, handhold everyone through the process, or, you know, babysit the compliance, or, you know, be abreast day to day. What the notice says is once the property is brought into the compliance, that they're supposed to contact the city to have an inspection, right? And our staff does a phenomenal job at following up with property owners and trying to work with property owners to assist them and providing them with all the resources they need and contacts within the city. But I just think that, you know, our role was to contact the person on file with the property appraiser, which could be the registered agent or property manager or whoever, and that sounds like what our staff did at this point.
Just for clarification, because I don't disagree with anything that the city attorney said, but a good way to think about it, right, is that in any given case, property can be held in lots of different ways, right? And you could have personal ownership, you could have a limited liability company, you could have a lot of different ways. And so what the Florida statutes attempts to do is clarify so that it's clear who the city has to notice in order for there to be proper notice in the case. And one of the things you might notice in your orders is that you always make a finding of whether there was proper notice or not. And that is governed by Chapter 162, and it literally tells the city, this is the person you have to notice. And just for, you know, for simplicity's sake, it is typically, as is written in the statute, the person that the property owner puts on the property appraiser records. Right. And so the city doesn't have to chase additional people, though sometimes as a courtesy, if the city knows somebody else is involved with the property, they will cite or let them know. But the requirement for them is to cite whoever is listed in the property appraiser's record. So it doesn't really, it's probably not worth a lot of your effort to spend too much time trying to see, you know, who else they might have talked to. As long as they did what they were supposed to, then the only next question for you is whether the property is in violation as you understand it. So to make those factual findings.
And Mr. Wagner, just to clarify, in addition to notifying the person in the property assessor's records, they also typically place a notice on the property itself, and they are required to post it here in City Hall.
Yeah, they follow. Yeah, so you always see the officer typically, as is their way, they will testify as to the procedure that they followed to do notice, and that typically involves registered mail and regular mail, along with posting at the property and posting in City Hall. And you probably, if that sounds familiar, it's probably because you've heard it repeatedly, because that's part of how they, you know, introduce the case.
I'd like to make a motion.
Thank you.
Discuss.
Okay.
Seems like we are in agreement. The code enforcement officer has went above and beyond in contacting he's supposed to. So it's $250 or more reasonable fine to get the attention of the homeowner, or the actual owner, because they've gotten the information, but they're hiding behind the registered agent.
I think I directed my question to the officer to get those answers, and I thought the answers indicated that there was not a response from the actual owner,
Correct.
and that this is, a comment made by him was this isn't an overnight thing, this is an ongoing thing. And I would have to say, being a citizen on this board, that property, they need to be made aware.
Correct.
And I think the minimum fine doesn't necessarily make them aware. So I have to agree with you, Jimmy, totally.
250 is fine?
I'm fine with 250.
Yeah, I have to agree. If it's an LLC, I mean, you just.
We can't bring that up.
You
Okay.
don't, well, but you know that's the fact, and it's not hidden. Here it is.
So let's discuss the fine.
Okay, and it's, you know, if it was a single person, like we had the previous
So,
case.
let's get the
woman
motion.
owner, it's way different with LLCs. We have problems with them all the time.
Okay, Mr. Chairman, I'd like to make a motion with respect to case number 00126. I move for finding a fact.
One extra zero in there.
I'm sorry, 000126. I move for finding a fact and conclusion of law that there is good notice and violation of the building maintenance exists on the property. The offending property shall correct all violations within 30 days or pay a fine of up to $250 per day for each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. The officer shall report back to the board, and in the event of non-compliance, a lien of the daily amount shall be imposed on the property.
Thank you. Second?
Second.
Moved and seconded. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes. Thank you.
Thanks, co-board.
We're about 2 hours in here. Do we need to take a brief break for bathroom, or are we ready? Want to keep moving?
It's up to you and the board.
You're the boss.
All right, let's keep going.
Keep going, okay. Case number 9 on your agenda, code 25-000132. Property owner Rosebud Ray Shops LLC, registered agent CM Rack Incorporated. Property address 245 Northeast 2nd Avenue, presented by Code Officer Delinda Wachowski.
Is there anybody present who, sir, why don't you come up to the podium here? You can give your name and your address for the record.
Good. My name is Solomon Stroll, 253 Northeast 2nd Ave, Delray Beach, Florida, 33444.
Thank you, sir.
Good afternoon. My name is Delinda Witkowski. I'm a code officer for Clean and Safe. I'm here regarding a grand opening banner violation located at 245 Northeast 2nd Avenue. On August 2nd of 2025, I inspected the property where I observed a grand opening banner that had been installed for an extended amount of time given by ordinance, which is in direct violation of our code section 4.6.7, subsection F, subsection 3, subsection B, states that a grand opening banners may be placed on a building of a newly opened business for a limit of 4 weeks with an approved permit, and 1 per building. Therefore, notice of formal hearing was issued by first class and certified on September 16th of 2025. A certified confirmation was not received. Regular mail was not returned. Posted at the property and City Hall on September 17th of 2025. A reinspection prior to hearing was conducted on October 1st of 2025. As of today, the violation continues to exist. I do have 3 photographs that I would like it to introduce into evidence.
Thank you. I'm now showing you has been previously parked as City's Exhibit 1 for identification purposes. Do you recognize this?
Yes, this was taken on August 2nd, was the initial photo taken of the property with the temporary banner on top.
What is the name on the banner?
Perna Boutique.
Okay, thank you. City's Exhibit 2?
Okay, this is my last reinspection photo that was taken on October 1st, just showing that the temporary banner for the grand opening continues to be on the building.
Okay, for purposes of temporary banners, we may have discussed this before in a previous hearing, but individuals are allowed to apply for a temporary banner for a certain time frame, correct?
Yes, they have to apply, and temporary banners are for a period of, technically what they do is they apply for this to be able to get a permanent sign. So this is allowed for a period of 4 weeks and 1 banner per building.
All right, this has been going on for months.
This has been going for a long time. And just so that the board is aware, this is a different violation, different ordinance, so it technically doesn't have to do as where is the position of the permit and everything. It's technically, it's past its time. It needs to be removed.
Okay. I'm now showing you what has been previously marked as City's Exhibit 3.
So this is just, the sign, it's been, he did apply for a permit, so it's different case, it's a different violation. It's just the fact is, the violation is just that he's extended the amount of time, and the temporary banner has been way past the 4-week period.
All right, so just for clarification, because you brought this up a second, just so there's no confusion. There's a separate process for a temporary banner, and there's a separate process for a sign permit, correct?
Yeah, from my understanding, I talked to Jennifer Buse. She's the responsible for all the signs and stuff. So basically, they're allowed the temporary banners, like when they're in preparation of opening. They're not yet have their sign approved or not ready yet. So they have a temporary banner.
But this sign permit has nothing to do with that temporary banner, correct?
No.
Okay, thank you. That's what I just wanted to make clear. All right. At this time, I'd like to introduce the 3 exhibits into evidence.
Mr. Chairman, I'd like to motion that we accept the 2 photographs and the 1 statement into evidence as presented by the city.
Second?
Second.
All those in favor?
Aye.
Any opposed? Okay. You have an opportunity to question the witness, Ms. Witkowski, and to provide any rebuttal testimony.
Okay. Yeah, so I have no questions for her. We had the temporary banner. We applied for the permanent sign. That permit process has been taking a really long time. We, I think, finally got that figured out this week, so we're going to be, I think we're going to have to resubmit. I'm not 100% sure yet, but we should have the permanent sign handled within the next month.
Okay. And does the city have a recommendation?
So basically, we're trying, because I know that he's been working very well with the city and going back and forth, and so he's making an effort to give him another 30 days to remain with that banner until his sign is ready and hung. So 30 days until the approved permit, and or $100 per day thereafter for non-compliance.
Okay. And do you think you can get that completed within the next 30 days?
Yeah, I believe so.
All right. Any questions from the board? Someone want to make a motion then?
Just real quick.
Yeah.
Okay. Just to be correct, we're going to allow 30 days for the banner to stay up, correct? You won't be fined.
30 days to come into compliance.
He won't be fined for 30 days,
Okay,
but
so-
after the 30 days, he does have to remove the
Okay, so
banner
it's 30
if the
days
sign's still not up.
To have the banner up and get rid of it.
Yeah, I think we're
I think
conflating
we're-
2 different code sections.
Right,
and
right. All,
So,
all we're
can I-
doing,
can I
I'm the chairman here, thank you.
No.
So as I understand it,
I was just going to rephrase our recommendation
Okay.
to the board.
all right, if you'd like to.
So I was going to rephrase and make an updated recommendation so there's no confusion. Come into compliance by removing the sign within 30 days. So there's no
Okay.
issues with the other
Perfect.
code
Fine.
section. Thank you.
Yep. Okay. So any motion made should be to come into compliance on the code issue that is in front of us, which is the temporary banner, and the city is recommending 30 days for that period. No connection with any other signage that they give.
Mr. Chairman, I would like to make a motion with respect to case 2020, code 25-000132. I move for finding a fact and conclusion of law that there is good notice that the violations of a use of a grand opening banner without a permit can remain until such the end of 30 days has to be removed, at which time the tenant, the owner will makes action to provide get a permit for a permanent sign. The offending party shall correct all violations within 30 days or pay a fine of up to $100 per day for each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If a violation is not brought into compliance, the code enforcement officer shall report back to the board, and in the event of non-compliance, a lien for the daily amount shall be imposed on the property.
Second.
I am sorry, I'm
Before
going to
we
have to make a
second-
correction on that
No,
because
sorry.
you said a temporary banner without a permit. They had one. It's just extended the time. So you just need to make an amendment.
All right, all
Yeah,
right.
and no reference to permanent
And that applies,
signage.
you're calling it the grand opening banner?
Correct.
That you're applying this to,
Correct,
right? Okay, all right. As opposed to just a temporary, which is different somehow, right? But, so there's two different sections. This is, the grand opening banner has got its own little section in the code.
It's a different ordinance that
Understand, right, yeah, okay.
Correct.
Understand, all right, so, the wording would be they are given an extension for 30 days to retain the existing grand opening banner, at which time they will take that down and proceed to get the permit for a permanent banner, a sign.
Good enough.
Is that all right?
I don't think we need to have reference to their permanent signage. All we want to do is have them remove this banner within 30 days to come into compliance by removing this banner. Anything else they do, they can go without a sign. We don't care if they have a sign or not.
Correct.
That's not our purview here. So
All right, I thought he said that in which case they would proceed.
they're working on it.
Okay.
But that's not our purview.
If all we want to do is say you give them an extension of 30 days for the grand opening, that's fine also with me.
Not actually giving them an extension. What you're doing is you're finding a violation and giving them 30 days to correct it.
Right, understand. Extension of time.
Can you modify the motion based on what we've said, or do you want it restated?
I think at this point you probably need to restate it.
Yeah, the violation of a grand opening banner without a permit they shall be allowed to retain that grand opening banner for an additional 30 days.
No, just the violation exists and that they have up to 30 days to bring it into compliance.
All right, the violation exists that they have a grand opening banner that was not permitted and is expired, but we will grant them an extension of 30 days.
You're
to
just going to
retain
give them
that.
30 days to come. There's no extension. You're just going to give them 30 days to come into compliance.
30 days to come into compliance.
It's actually simpler than you're making it.
Just
All right,
read
all
the
right.
motion as
30
it
days
is.
to come into compliance relative to the grand opening banner.
Yes. Second. Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? All right, thank
Thank
you.
you.
Okay, thank
You
you, guys.
have 30 days now. You are out of compliance technically, but you have 30 days to come into compliance.
Got it.
And then the city can begin, bring it back to us so we can fine you. So,
Understood. Thank you.
okay, thank you.
Thank you for coming.
Thanks.
All right, next case.
Next case, case number 10 on your agenda, code 25-000145, property owner Katie Meckler, property address 110 Southwest 9th Ave, presented by Code Officer Reggie Williams.
Anybody here in the audience on this case? All right, seeing none, let's go ahead.
Good afternoon. My name is Code Enforcement Officer Reggie Williams. I am here regarding maintenance of building violation located at 110 Southwest 9th Ave. On August 13, 2025, I inspected the property where I observed the property in need of maintenance of building, which is a violation of Code Section 7.8.3, which states all buildings or structures, both existing and new, and all parts thereof, including all materials, fixtures, and appliances installed therein shall be maintained in a safe, secure, and sanitary condition. A maintenance of building violation was issued on August 13th, 2025. The violation was mailed first class and certified mail on August 15th, 2025. The compliance date was required by August 27th, 2025. On August 27th, 2025, I re-inspected the property. Subsequently, a notice of formal hearing was issued via first class and certified mail on August 15th, 2025. Certified confirmation of receipt was not received. Regular mail was not returned. Posted at the property and City Hall on August 19, 2025. A re-inspection prior to hearing was conducted on August 2nd, 2025. As of the last re-inspection on August 2nd, 2025, the violation still exists. I have 4 photographs taken of the property in question. I would like to introduce these photographs as evidence. I have had contact with the property owner.
And what was the contact with the property owner?
I spoke to her August 27, 2025, and informed her that she needed to board up the property for the door and the windows. She was contacted by the police, and they informed her that she might have people living inside, so she applied for a no trespassing sign. I contacted her again September 9th, 2025. She at that time, she still had boarded anything up, but she told me she was still waiting for the trespassing sign, and that was the last time I had contact with her, September 9th, 2025.
So she's aware of the violations, and you tried to assist
Yes.
her with trying to find ways to come into compliance.
And I informed her of the board hearing and everything.
All right, thank you. I'm now showing you has been previously marked as City's Exhibit 1 for identification purposes taken on August 13. What does it depict?
This photo was taken August 13, 2025, and it shows the broken window and the door that doesn't have a door handle, so it's easy access.
Thank you. City's Exhibit 2.
This was taken August 13, 2025, and this is in the front of the porch, and you can see the ceiling is rotted out.
Okay. City's Exhibit 3.
This was taken August 2nd, 2025. The same ceiling is rotted out, and you can see the front window is now broken, and I believe somebody put a cardboard box in there to cover it. And the roof is still rotted out, yes.
Thank you. City's Exhibit
This was
4.
taken August 2nd, 2025, and it shows the same window broken and the same door missing the door handle with easy access.
All right. At this time, the city would like to introduce the 4 exhibits into evidence.
Mr. Chairman, I'd like to motion that we admit the 4 photographs presented by the city into evidence.
Thank you. Second?
Second.
All those in favor?
Aye.
Any opposed? Thank you. Does the city have a recommendation?
The city suggests that the property owner be granted 10 days to bring property in compliance or face a fine of $100 per day until a violation is corrected.
And that is because there's issues with potential vagrants based on the police complaints.
Yes.
And what the information you obtained from the property owner.
Yes.
Thank you.
I do have a question.
Go ahead.
To bring this into compliance, what does that mean? Board it up? Or
Yeah, I when I spoke to her, I told her to come into compliance. She will have to board up the windows, the broken windows, and the door.
And also fix the under.
The rotted, the front porch, the rotted ceiling.
So is 10 days sufficient to fix the? I understand 10 days sufficient to board up.
Right.
But what about to fix the roof?
Yeah.
Because of safety issues, I only granted 10 days because of the windows and the door. But I understand what you're saying about the ceiling. Yeah, because she might have to.
Let me help you because there's a solution to this problem. You can bifurcate the order, right? Which is you can give them 10 days to board up the place and then more time to finish the repairs, and maybe that would solve the problem here, because and address the city's concern.
All right.
And I have one other question. Can you go back to picture 3, Exhibit 3, please?
Yes.
Is that notices there that's depicted, is that something that the property owner put up, that you put up?
Those are notices that I posted to the property.
Okay. Thank you.
One more question. So it looks like the property owner does live in Florida, just not in Delray Beach.
Yes, correct.
So the language I would use, just as a suggestion, going back to your first motion, you could say the offending party shall correct actually I'd probably say it like this: the offending party shall secure all the entrances to the building within 10 days and complete all other repairs within 30 days, just a round number or something like that, depending on what you think is appropriate.
I'd like to, thank you. I'd like to ask you a question, Mr. Chairman.
Yes.
I think staying consistent, judging by the evidence and the safety issues from the testimony of the officer, that we consider a fine of $200 a day, because we're asking for 10 days for initial compliance for the main things. I think this is a situation where there's safety of other people in the neighborhood. Children could get locked in there, things like this. So I think we should have, along with 10 days for the first part of the bifurcated order, we should also maybe go to 200. Do you guys agree, or?
So, Mr. Wagner, just to clarify on the bifurcated order, if they do not meet the first part within 10 days, the city presumably could begin the fine process then. Okay. And then if they do meet that part, but they don't meet the second part within whatever days, we proceed.
Failure to meet either deadline would trigger the fine,
typically
in how these are written.
So for a point of information, let's say they don't meet the 10 days, but in 30 days they complete everything.
Well, that would be the same as in any case, right? Once they come into compliance, they report that to the officer, and then they find, that they're in compliance, and then the fine would run for the time that they were out of compliance.
Okay, thank you.
Want to make Make a motion? Somebody?
I'll make a motion. Mr. Chairman, is there any more?
You gonna do that bifurcated order?
Okay. Mr. Chairman, in regard to case number 25-000145, I would like to make a motion with respect to that case. I move for a finding of fact and conclusion of law that based on the testimony of the officer, the photographic evidence, there's good notice and violations exist. The violations include a ceiling with holes in it, a front window with cardboard in it, side windows broken open, and a back door improperly secured. This exists on the property. The offending property shall correct the violations of the broken front window, secure the back door, and any other broken windows on the property within 10 days, and correct the holes in the ceiling within 30 days, or pay a fine of $200 per day for each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board, and in the event of non-compliance, a lien for the daily amount shall be imposed on the property.
Thank you.
Second.
All those in favor?
Aye.
Any opposed? Thank you.
Thank you.
All right, next case.
Next case. Case number 11 on your agenda, code 25-000150. Property owner, American Atlantic Group LLC, registered agent, okay. RA, property address 338 Southridge Road, presented by Code Officer LaToya Thompson.
Is there anybody in the audience? Thank you. Come up here, state your name and your address for the record.
My name is Imtiaz Ahmed, 2826 Waters Edge Circle, Green Acres, 33413.
Sir, what is your position with the property owner?
Well, Mr. Huck is in treatment. He has a brain tumor. He goes back and forth to New York. So he has hired me as his contractor to pull a permit for the fence.
Okay.
Yeah, it was mixed. The slides were mixed up. Okay, you may proceed.
I'm back, Code. How y'all doing?
Welcome back.
Okay, copy that. Good afternoon. My name is LaToya Thompson, Code Enforcement Officer for the City of Delray Beach. I'm here regarding a chain link fence installed without a permit violation located at 338 South Ridge Road, Delray Beach, Florida. On August 12, 2025, I inspected the property where I observed a chain link fence around the property that was installed. After further investigation, I observed that there was no permit on file for the installation. This is in violation of the City of Delray Beach Land Development Regulation Code 2.4.13, subsection B, building permits, which states a building permit is required for all items as set forth in the current Florida Building Code, Chapter 7 of these land development regulations as amended. A building code shall be sought via application through the Development Service Department. A general/formal hearing notice was issued August 18, 2025. The violation was mailed first class, certified on August 20th, 2025. Compliance date was required September 18th, 2025. Certified confirmation of receipt was received September 29th, 2025. Regular mail was not returned. Posted the property and City Hall September 20th, 2025. A reinspection prior to hearing was concluded on October 6, 2025. As of the last reinspection on October 6, the violation still exists. I have 5 photographs taken of the property in question. I would like to introduce these photos as into evidence, and I believe we spoke, if it's not you, the owner, one time regarding this property.
All All right, I'm now showing you what's been previously marked as City's Exhibit 1 for identification purposes. When was this photograph taken and what does it depict?
This photograph was taken August 12, 2025, and it depicts a chain link fence around the property.
Okay. City's Exhibit 2?
This
Same
is,
questions?
This is just another angle, and it's also taken on August 12, 2025.
City's Exhibit 3?
This was my reinspection on August 6, 2025.
So the fence was still there?
Fence was still there, no permit applied for, and this is just a different angle on August 6, 2025.
City's Exhibit 4?
This is another angle of the chain link fence around the property, taken on August 6, 2025.
And City's Exhibit 5?
This is just a depiction of the permit not being applied for, no result when searched.
All right, so you searched city records and there was no permit?
Yes, ma'am.
Thank you. At this time, the city would like to introduce the 5 exhibits into evidence.
Can I get a motion?
Mr. Chair, I make a motion that we admit the 4 photographs of the chain link fence together with the empty Exhibit 5 showing that there are no outstanding permits covering the work.
Second.
Thank you. All in favor?
Aye.
Any opposed? The exhibits have been admitted. Sir, you have an opportunity to question our witness or to provide any rebuttal testimony.
No, I don't have any questions. I was hired by the owner. I'm a general contractor. So since he has a health condition, so he travels a lot to New York for treatment. So he has asked me to go ahead and file for the permit, which I plan to do on Monday. I'm going to register with the city building department with all my credentials, and we will file for the permit on Monday.
Okay.
He told me that he installed that because there was a lot of garbage being thrown by residents, so he wanted to keep them out. But he didn't know that he needed a permit. So anyway, I'm going to apply for the permit.
All right.
To clarify what I was looking at in the photo, in the background there's a group of buildings, look like a multifamily dwelling compact. Is that inside the fence or is that separate from the fence? Is the fence just the vacant lot? What is the fence?
That is commercial property.
It's a vacant lot.
And it's outside of the
so
lot.
That property is outside the fence we're talking about. The
Yes.
fence is just around the vacant lot?
The vacant lot.
Just
Yes.
around the vacant lot. Yes, sir.
Thank you.
And does the city have a recommendation?
The city recommend 30 days to apply for and obtain all approved permits, or $100 of fine thereafter.
Okay. And do you believe you can get that permit completed within 30 days?
This is the first time I'm applying in the city of Delray Beach because I'm going to apply on Monday, so I hope I'll get it. If I don't, I don't know.
Okay. But you can work with the code enforcement officer, let her know what your progress is and if there's any...
Sure. I will be applying on Monday for sure.
Okay. Any questions from the board? Someone want to make a motion?
Quick discussion before we make the motion.
Yeah.
Because he's not familiar with the inner workings of the city of Delray Beach, he might be from out of the area, and considering it's in a commercial area, it doesn't seem like it's intruding on anyone's privacy or enjoyment of quality of life. 60 days and 0 fine, if that's okay.
I got a question on that. For my name. Mrs. Officer, have you had prior communication with the owner before he fell ill?
I believe I spoke to someone, I can't recall, regarding that. As you see the first 2 pictures, the grass was high, and so that was the main concern. Then I seen the chain link fence. This is not my first time dealing with this as far as cutting the grass. The fence went up and I was like, they didn't have a permit, and I explained to them, I was like, you have to cut the grass, which they did, but I didn't know that the owner fell ill.
Correct.
So I did explain that they need a permit for the chain link fence.
And do you feel that 30 days is adequate enough time for the permit? Being we do understand this is his first time with the city, and the city does have some backlog, adequate time to come in compliance.
Did we hear testimony that the city had backlog on fence permits?
In general.
I believe that 30 days is, I will speak to him outside of your ruling, and give him instructions on how to go about applying for it.
Just so we're clear, you will assist the individual.
Yeah, absolutely.
And coming into compliance within 30 days.
Of course. We want voluntary compliance.
Do you know, or have you ever been given a current survey of the property?
No, I don't have
You'll
that.
need that
Yes,
survey
I'm-
for the permit application.
That's correct,
So
yes.
That's a pretty good question.
survey timing. Got
You don't have a survey?
I got to check with the owner. He's going to look for it, but since he's very sick, so he's taking some time to get me that.
Just for discussion, it seems like he's willing to comply. The city is trying, and I now understand why I say 60 days. Give them some time to get it together.
Guy's got health issues, he doesn't
Yeah.
have a survey, it could take 2 weeks for a
I
surveyor to
understand.
come out, a week to send it back.
I like the 60 days. I think zero fine may be not great. I think even a small fine, but having it there is better than having a zero fine. So
What do you suggest, Mr. Chairman?
I would suggest $50 a day if we're going to decrease the fine, but
You and me both, Mr. Chair, and I was thinking the same thing, but you took it right out of my mind.
Mr. Chairman, I'd like to make a motion.
yes, go ahead.
With respect to case number 000150, I move for finding of fact and conclusion that the law there is good notice of violation of the fence exists on the property. The offending property shall correct all violations within 60 days or pay a fine of up to $50 per day for each day thereafter for noncompliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board. In event of noncompliance, a lien for the daily amount shall be imposed on the property.
Second.
Thank you. Any further discussion? Hearing none. All those in favor?
Aye.
Any opposed? All right, sir, thank you.
Thank you
And,
very much,
You
sir.
have a
Thank
clear
you very much.
understanding now. You've
Thank you,
got
I
60
appreciate it.
days to get that done, right? Okay.
We're
Next
almost
item.
there. We're almost there. Case number 12 on your agenda, code 25-000160. Property owner Pineapple Grove Development LLC. Registered agent 121947 LLC. Property address 301 Northeast 2nd Avenue. Presented by Code Officer Delinda Wachowski.
And sir, you're here for that case?
Yes, I am.
And your name and address?
My name
for
is
the record.
Abel George Lucas. I am part owner and manager for Pineapple Grove LLC.
Okay, and address?
The address is 945 Palm Trail.
Okay, thank you.
Good afternoon. My name is Delinda Witkowski. I'm my code officer for Clean and Safe. I'm here regarding a work without permit violation located at 301 Northeast 2nd Avenue. On August 16th of 2025, I inspected the property where I was driving in the back alley, noticed several workers working in the back with stucco, ladders, and they were just in the back, mixing up stucco and stuff like that. So I had stopped and asked them if they had a permit. There was nothing placed on the windows, as there should be. And so this is in direct violation of our code section 2.4.13B that states that building permits are required for all items set forth in the current Florida building code. The notice was sent by formal hearing, first class and certified on August 29th of 2025. Certified confirmation was not received. Regular mail was not returned. Posted at the property and at City Hall on August 29th of 2025. As a reinspection prior to hearing was done on August 2nd of 2025. And as of today, the violation continues to exist. I do have 13 photos that I would like to introduce into evidence for this case.
So I just want to ask you a couple questions before we even get to the photographs. So you stated that you patrol this area, you went and you noticed that you saw workers doing work without any permits.
Correct.
And where at this point you were still kind of in right-of-way, public right-of-way, outside, you weren't inside of the property, correct?
No, not at this time. I usually, when work is being done, I always confirm in the front office for if there's a permit.
Before we get there, let me take you there.
Okay.
So you're outside, correct?
Correct.
And then this photograph is of you outside, what you saw.
Correct.
And could you describe in this exhibit, what did you see happening at the property? What is all this stuff on the ground? Is that a ladder? Could you just describe the photograph?
Okay, so there's stucco there on a pallets and buckets, ladders, andame, that's in Portuguese. I'm not sure what that is in English, but it's all the work to stand on to do their stucco work. So and there was a few guys out there, but
It's called scaffold.
I avoid getting them in the pictures, so they were kind of on the outskirts.
So you said there were a few guys doing what outside?
They were mixing up stucco.
Okay, mixing up stucco. All right. So that's Exhibit 1. So City's Exhibit 2, August 16th, 2025. What does this depict?
So on August 16th of 2025, also just the closer view of the supplies that they were using on the outside.
We got stucco, we got concrete, we got pallets that they,
Correct.
Something that was standing on, correct? This is what you observed on that date?
Yes, ma'am.
City's Exhibit 3 for identification purposes.
Okay, so at this time, I do believe he also even called George, which is at that day, but I don't think he answered. And I told the guys that I did need to go inside to take photos, and they said okay. So I went in, took closer photos of the work that was being done.
So you spoke to someone that was doing work,
Correct.
that had authorization for the property, correct?
They were working for him.
No authorization.
They gave me authorization to go in.
So they allowed you.
They allowed me to go in.
Thank you. I just want to be clear on that. Okay. And this photograph was taken on August 16, 2025?
Correct.
And where is this in the property and what is it?
This is inside. So it was actually it's two different locations, 301, 303, and he divided the bay and made it into two. So that wall, you'll see in other photos that you'll see that there is a division of the wall, which is a bay which was not, he did without a permit.
And
That's the bay.
4?
That's the bay wall that was put up on the two different locations on the one full bay.
And that was on August 16th as well?
Correct.
So this was previously an open space, and it was subdivided with a new wall that was installed without a permit, and it appears that there's electrical wiring. Is that what you're?
Correct.
I think we talked about 4. City's
I
Exhibit 5?
know that because I went into that building. It was a gallery before, and I've been in there several times. That it was just one open area.
Okay. City's Exhibit 5?
So this is just all the drywall that was placed on the ceiling, the walls.
City's Exhibit 6?
This is the bathroom, just the plumbing walls. Nothing has been installed yet.
All right. So, but there's like pipes and different things sticking
There's
out.
pipes. Yeah, it's.
If I may.
It's,
Okay.
Yeah, we're just
You'll
trying
have
to
your
get you to
opportunity. Don't worry.
Okay.
Just describe what's in I just want to be clear,
So this is the bathroom basically, but as of yet, nothing has been installed.
Okay. And that was on the 16th. What about City's Exhibit 7?
So this is patching of stucco and stuff that was done on a few different locations of the wall.
Is that the exterior or interior wall?
That's the exterior.
Thank you. City's Exhibit 8?
So this is a little further north of the building, which was also done a little bit more of stucco.
All right, and that was on the 16th?
That's on the 6th. Yeah.
All right, so let's go now to Exhibit 9. I'm assuming this is re-inspect on October 2nd, 2025?
Yep. This is re-inspection prior to hearing, which was October 2nd, which I was not, no one's working there anymore, and so I just took it from the outside.
So you were standing outside and took a picture of this?
It was closed, so I was not allowed in. I didn't go in.
Well, you were outside and you were able to see this from the outside inside of the building?
Correct.
All right, thank you. City's Exhibit 10?
Yeah, I just took what I could from the outside. There was a lot of glare, so it was a little difficult, but this is just so I could have some type of re-inspection photos.
So August 2nd, there's a wall, there's building materials. Could you describe what's in the photo, please?
So there's buckets of paint, ladder, just a couple other different supplies.
Thank you. City's Exhibit 11?
And so this is just on October 2nd, which was the work was complete. And the stucco issue is not as big of an issue as far as the division of the bay and electrical and plumbing work.
But it is showing that there was stucco done.
Correct.
Okay. City's Exhibit 12, October 2nd.
So that's just the part of where that was down north a little bit of the building, which was the stucco that was complete.
So this is so just to be clear, we're going back to August 16th. So is this the same area?
Correct.
Okay. And that was Exhibit 8 and 9. I just wanted to be clear for the purposes of the board.
Correct.
And then City's Exhibit 13. What were you able to locate regarding any permits?
As you can see, in 2021, the last permit that was pulled was for backflow, so he had not applied for any permits whatsoever.
Okay. At this time, the city would like to introduce the 13 exhibits into evidence.
Get a motion to that effect?
Mr. Chairman, I move that we accept the 13 photographic exhibit, 12 photographic exhibits and the one list of backflow permits presented by the city as evidence of the work.
And second?
Second.
Thank you. All those in favor?
Aye.
Any opposed? All right, sir, you have an opportunity now to
Okay.
question the witness and to provide any rebuttal testimony.
No problem. So originally, we were going to knock down this shopping center to build townhomes. After having a lot of meetings with a lot of people from the association, they would prefer to leave it as a shopping center. So we decided to do that. Then we also own the lot in the back. We're going to be building. We're working with the city because I'm a builder. Within the last 7 years, I invested almost $100 million in the city of Delray. So with that said, I know what I need permits and what I don't need permits. It's like asking a chef how to fry an egg, right? But okay. So my question here was, we were going to knock it down, and we decided to keep the shopping center, and the shopping center was in really bad shape. We wanted to make it look nice for the season, and we were going to rent it. We decided to rent it, so we just started doing stucco repairs and give it a nice paint job. We did the landscape outside. We fixed all the irrigation systems, so the place actually now looks beautiful. Now on those two bays, 301 and 302, I believe, 303, those two bays, at one point had a wall, but somehow somebody, not under our ownership, they removed that wall, right? So now what I did was I just brought back the wall, which that was still the header, and the wires for the electrical were rolled up there. So we just brought it down. Me as a builder, I'm like, this is what I do every day. Mr. Tobias knows me, how many permits have I pulled in my lifetime within the city. I know what I'm doing with no, of course, I understand, and I know the rules and the regulations. We need a permit. I get it. I understand that. So we just said, you know what, let's go ahead and do it because I want to have the property vanilla shell ready, so therefore I can rent it. Which I end up by putting, because I own Center 21, Lux Homes, and I'm actually bringing my office there. Which actually that wall that I put up, I actually got to take it down because I'm going for permits for me to redo my office over there, because currently I'm on Atlantic and Federal. But I'm renting, so I'm like, why am I renting when I have my own stuff? So I'm bringing my office over there. So all that worked for nothing, but anyway, I was just trying to rent and move on, right? With that said, Miss Linda showed up, and she has my phone number. She's always in contact with me because I was great friends with Al, and I never had any issues, even though I've been building for many years here. And he actually introduced me to Linda, and we stayed in contact. So she has my phone number. So I spoke with her the day of the violation, and I asked her, I said, Linda, I mean, this is what I do for a living, and okay, if you want me to tell me exactly what I want. Because outside for painting and stucco repair, it's kind of nonsense, right? She was heading to Brazil. She was going to Brazil, and I said, okay, great. Which I found out she was part of Brazilian, because I'm Portuguese, so I have no idea, but don't worry, okay. That's besides the point. So then I told her, I said, okay, great. And she said, when I come back, we're going to meet there, and we come up with a solution. And I said, great. And I have all the dates on my phone, everything, the text messages, everything. Then what was it? I'm sorry, I need my glasses so I can even see. Then on August 29th, I received a text. She said, oh, well, my boss said that I can't do anything, or I'm sorry, it wasn't on August 29th, October 2nd. So we left it in limbo because I'm waiting to hear back, because at one point we were supposed to meet there and come up with a solution. What are we going to do? So then October 2nd, that's when she sent me a letter, a text, saying that I had to show up at the meeting. At this point, left me with no window for me to go pull the permits, because I was waiting, what should I do? What was the solution that we were going to do? Now, some of the letters and I received the letter that she left on the wall. I received that letter, I saw, obviously, and I believe there was another one that came in the mail. So I know, but I was waiting to hear what was I supposed to do in the meantime. But so my point is this: I am not here at all about getting the permit, because I can get a permit like that. I have engineers on speed dial. I can get an engineer letter. I can get permits. I can do whatever. It's fine. That's not a word. The thing is that she walked into my property with no permission. When she had my phone, the day she walked in my property, I was in California, Monterey. My business partner was in Connecticut. So I had a phone with me the whole time, and therefore all she had to do was call me. If she called me and I see that it's Linda, I answer right away, because it's an issue, right? So, but she never called me. Now, she asked apparently either one of my landscaping guys or one of my stucco guys. They don't even speak English, none of them. And she asked permission to go inside, and they asked me, nobody asked us anything. Nobody ever asked us any permission. So my point here is, there are rules and regulations that we have to follow by, right? Now, I'm not trying to hide that I did an outlet or I put a piece of drywall. It's irrelevant for me because I can pull the permit. It's not, but that is rules and regulations. And she knows, she has my phone. Why didn't she call me on that day and say, George, you're doing work with all this, you need to go get a permit? I would have ran and get a permit. It was just instantaneous. I was just really trying to get the shopping center all finished, because if I leave a vanilla ready, whoever gonna rent it, they're gonna have to pull a permit anyway. They're gonna have to rip everything out to make sure everything is up to date. Now, there's no plumbing. That's an existing bathroom. We just took out the toilet and the vanity, and we leave it capped, because whoever comes in is gonna have to do their bathroom. Because the vanity that was there and the toilet that was there, they were no good, so we just cap it and we leave it alone. So whoever rents it, because it's called vanilla shell, whoever rents it gets to build it to their taste or specifications. So that's basically that. The only issue that I have with the whole thing is, and I consulted with my attorney, not my attorney, because actually I spoke with Phil, one of the supervisors, the coding supervisors. I spoke with Phil, and Phil asked me, how did she get access to your property? I said, I don't know, because I didn't give her any permission. She didn't call me. She didn't call my my partner. She didn't call our office, and they know where my office is. They didn't call my cell and let me know or ask permission to come in. I mean, it's like somebody walking in your house, in your living room, and telling you, oh, you need this, you need that. Well, you didn't give them any permissions. So that's the issue that I have. It's not the issue so much of having to go get, but as far as the permit situation I was just really, really waiting to hear from Linda, what did she want me to do? And she left me in limbo for almost a month between Brazil and then getting by the way, you have to show up at the court. And I have it all documented in my phone too. So and the dates, the times, everything.
I understand that you're frustrated about that. We're interested in compliance. You've already said that you acknowledge that you've put up that wall.
Right.
That actually, regardless of what your understanding was at the time that you put it up, that you now understand that a permit was needed if that wall is going to be there, and that you're willing to take steps to get that addressed. Either remove it if you're going to move your office there, or leave it up if you're going to rent it and get the permit necessary.
Correct.
So what kind of time frame do you need to get that done in?
I think 30 days, I can get the permit done. The only thing is that now that I'm bringing my office, I actually have my architect working in a layout.
Take it back to
I'm going to rip out that wall again. So it's kind of...
So why am I getting within 30 days you can get the compliance? Because compliance in this case could be the permit or removing the unpermitted work.
Yeah, so it seems like
but we also have the outside
Mr. Chair,
stucco, right?
I would like to respond to him on my defense, though.
No, I think the issue at this point is we hear the frustration.
Yep. Yeah.
We've already stated, I asked you an extensive amount of questions about where you were and why you were there and who authorized you to be there.
Because his
I
worker
think-
called him.
No,
Well, let's
At that
let's
time.
let's
Right,
not
right.
get, let's
And
not
I
even
just-
go down that road.
I just wanna
That's done.
streamline this.
Let's get to compliance.
Right, exactly.
So
So I think he's definitely willing. It sounds like he's
Yep.
willing. He
No,
knows. Right.
it's because now we decided to bring the office over, and we invest a lot of money in the city of Delray. I mean,
And
how many houses have we built? Like
as
30.
a resident of
you
the
know,
city,
so,
I
right.
appreciate that.
And we have our business here. We constantly opening business, and we spend so much money. And I used to spend. I was a Fort Lauderdale boy, and then one day a friend of mine convinced me to come to Fort Lauderdale. And we spent $100 million here between all the houses. I developed all South Lake, North Lake, Palm Trail. I developed all those areas. So okay, I'm not just trying to improve myself, but now that I'm actually knocking down the wall because it's
does the
kind
city
of like,
have
what
a
do I do? You know?
I do. I have a suggestion.
Yes.
We're just asking them to bring the property into compliance. It sounds like the wall was
Right.
an issue. So, however he decides
Right.
to do it within 30 days or $100 a day. It sounds like he's.
Yeah, so I'm working with my architect.
Right.
But okay, so what happens is I'm only taking the one bay. So the one side of the wall will probably remain though. But I was going to incorporate that wall in the new drawings that I have to submit.
Right.
Because I have the partitions that I'm going to be building for the office.
So that would be compliance from the city's point of view.
So I will put that wall together within my permits. But with that said
But I mean, it depends on if there's exterior changes or any other internal changes. I mean, there's these
Right, you'd
views,
still have
there's
to get
site
a-
plan, his approval, but he knows. You know.
No. There's no outside work or anything.
Well,
It's just
it
partitions. It's partition
But-
walls that we are doing. So
Everything we need to do.
Yeah, so compliance within 30 days.
So I
Compliance
might
may
need-
be a permit, maybe removing the wall, whatever you choose to
Right.
get into compliance
If
but
I-
within 30 days.
if
is
it's
that-
okay, because within getting the engine, because now we're going to the architect.
So you need a little
Having
bit
the
longer.
architect finish it up, signing seal permits, and then I have to submit this to the city. It might take like 60 days.
Okay, so
And I don't want to ask for much, but that's real time, you know.
I think we
Am I right, Steve? More or less 60 days? Yeah.
Okay.
I just have one question.
We're amenable to 60 days if the board wants to make the order, 60 days or $100.
Thank you.
That was my question, but I do have another question. Is there any issues outside? Let's say, because we understand this issue you're going. Were there any permit issues for the work that he was doing outside?
No, the outside was not, it was a little bit of stucco, but if it's not the whole thing that has to be stuccoed, he's okay with the outside.
So it's just
It's
on
mainly
the
the inside, the bay, and electrical.
Okay.
So 60 days?
Yeah, 60 days. We're gonna get it in because I have to move. I have to move where I am now. I have to be out of there by December 1st. So.
Can I make a comment?
Yes, please.
So we are. It seems like you are willing, but you did say you know what you're doing. So if we see you back in 60 days.
Oh no!
We just want you to come in compliance.
No! It was just a loss of communication between me and Linda.
Okay.
Because she went to Brazil, and then I was waiting. I was really waiting to get together. Remember, you told me you were going to come and take
3
pictures.
days in Brazil, and I got
know,
back
but
to you.
then
when I
you
got
were
back.
supposed to come back, and we were supposed to meet there.
That's not our conversation. Thank you.
No, it's all right.
Jamie, do you want to make a motion?
Yes, I'll make a motion, Mr. Chairman. I'd like to make a motion.
Wait, does anyone have a comment?
Anybody got a comment?
You got a comment still?
You know, I love small businesses, but two wrongs don't make a right.
Correct.
You're too smart to be stupid.
No, and I agree with that. But with that said, if I may respond to you, it's we build mansions, houses on the Intercoastal at 13,000 square feet. When we look at a wall, and the wall, the wires are in the wall, and you just got to bring them down, put an outlet box. It's still wrong.
I come from a family of construction. I totally understand.
You understand? It's kind of like
be a role model for smaller businesses.
Yes. No. I understand, but it's kind of like you moving and you're not paying attention to
I
stuff
have one
like
more
that.
question. Are we gonna assess $50 or no fine?
100 is fine.
100, it's 100 or 100. Okay. Mr. Chairman, I'd like to make a motion with respect to case number 000160. I move for fact and finding conclusion of law that there is good notice and violation of the walls or violations inside the property exists. The offending party shall correct all violations within 60 days or pay a fine of up to $100 per day for each day thereafter for noncompliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board. In the event of noncompliance, a lien for the daily amount shall be imposed on the property.
Second. Thank you. Any further discussion? All those in favor?
All good. All right, thank you. Thank you.
Thank you, George.
All right, take care. I'll talk to you guys.
Sir, thank you again for your investment in the city and
Your beautiful
appreciate
project.
you.
Which one?
Yes.
Well, we're going to be building 6 gigantic townhouses in the back. So.
Well, I don't thank you for that, but
Well, it's business. It's income for us.
it is. It is.
I did my math. We spent just in permits here 1,150,000 in the last 4 months. In the last 4 years, I'm sorry.
Thank you.
All right, moving on to case number 14 on your agenda. Code 25-000170, property owner John Corneliev, property address 412 Southwest 4th Street, presented by Code Officer Reggie Williams.
Okay. Is anyone here for this particular item? Anybody present in the room for this item? All right. Thank you, Reggie.
Good afternoon. My name is Code Enforcement Officer Reggie Williams. I am here regarding landscape maintenance violation located at 412 Southwest 4th Street. On August 19, 2025, I inspected the property where I observed the property in need of landscape maintenance, which is a violation of Code Section 4.6.16, subsection I, subsection 1, which states landscaping shall be maintained in a good condition so as to present a healthy, neat, and orderly appearance at least equal to that which was required for the original installation and shall be kept free from refuse and debris. A landscape maintenance violation was issued on August 25th, 2025. The violation was mailed first class and certified mail on August 29th, 2025. The compliance date was required by September 10th, 2025. On September 11th, 2025, I re-inspected the property. Subsequently, a notice of formal hearing was issued via first class and certified mail on August 29th, 2025. Certified confirmation of receipt was not received. Regular mail was not returned. Posted at the property and at City Hall on August 29th, 2025. A re-inspection prior to hearing was conducted on August 3rd, 2025. October 3rd, 2025. As of the last re-inspection on October 3rd, 2025, the violation still exists. I have 4 photographs taken of the property in question. I would like to introduce these photographs as evidence. I have not had contact with the property owner.
Thank you, Mr. Williams. I'm now showing you has been previously marked as City's Exhibit 1 for identification purposes. Do you recognize this?
Yes, this was taken August 19, 2025, and this is the front of the property.
Could you describe the violation with the maintenance?
It's an overgrowth of grass that needs to be cut and maintained.
All right. And you can kind of see there's weeds as well.
Yes.
Thanks. City's Exhibit 2 for identification purposes?
This was taken August 19, 2025, and this is the back of the property, showing the overgrowth of the grass.
It's pretty high.
Yes.
City's Exhibit 3?
This is my re-inspection, October 3rd, 2025, and this is the front of the property showing that the grass grew even more.
Okay. City's Exhibit 4?
And this was taken October 3rd, 2025, and it's the back of the property showing the grass higher.
All right. At this time, the city would like to introduce the 4 exhibits into evidence.
Motion?
On case number, I make a motion on case number code 25-00017. We submit the articles and photographs into evidence regarding this case.
Second.
All in favor?
Aye.
Any opposed?
What is your recommendation?
The city suggests the property owner be granted 14 days to cut the entire landscape or face a fine of $50 per day until the violation is corrected.
Okay, so just bring the property into compliance
Yes.
within. Thank you.
Yes.
Okay. Board members, questions, conversation?
Is the owner local?
I'm not sure. I know that on Papa, it shows the mailing address as the same violation address, but I didn't have any contact with the property owner.
Okay, you say 14 days, but is he gonna come back every 14 days? Do you have any idea that somebody's ever gonna show up and do it and do it? It's not just a one-time job.
I have no idea.
Okay.
I never seen the property owner or had contact with the property owner.
Yeah, I mean, if-
That's always going to be my question. The intent of the property owner, communicating back with you, because you're doing an excellent job of reaching out. But like Mr. Cohen says, is 14 days going to be enough if we haven't talked to anybody?
I mean,
Was there a compliance date prior to this hearing that they were supposed to comply to or adequately noticed? And I think that was in his testimony. Could you repeat
Yes.
it?
The violation was issued August 25th, and the compliance due date was September 10th.
Thank you.
So that's 30 days ago for compliance date.
You had more enough time to respond.
Seems like a good question.
And I think for clarification, Mr. Wagner may have said this earlier, but it's from today, from the order, whether 14 days would be reasonable, and the city feels that it would be reasonable. We provided them a proper notice. We provided them proper notice of the hearing, and they will obtain the order.
Mr. Chairman. I understand the question because it's an interesting question, right? Which is, if the notice if they haven't been reading their notices, do they have enough time? But fundamentally, the city's obligation is to give notice to the name and address listed on the property records. It's their obligation to make sure that they're aware of the notices based upon the address and the name that they put in the records. So it's not that the city doesn't. I mean, imagine if the city had to go, run down every time.
Understood.
Chapter 162 says this is how you should let the city know how you be noticed, and this is how the city must notice. And so as long as the city follows that, then the question of reasonableness is based upon the notice that they're supposed to be receiving is, do they have enough time to come into compliance?
Okay. I'd like to make a motion.
Yes, please.
How many pictures were there?
How many exhibits? We already
4.
We
really?
brought the exhibits. It's just the motion to.
Mr. Chairman, I'd like to make a motion with respect to case number 000170. I've moved for finding of fact and conclusion of law that there's good notice and violation of the overgrown landscaping exists on the property. The offending party shall correct all violations within 14 days or pay a fine of up to $100 per day for each day thereafter for non-compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance. If the violation is not brought into compliance, the code enforcement officer shall report back to the board. In the event of non-compliance, a lien of a daily amount shall be imposed on the property.
Thank you. Second?
Second.
Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Thank you.
Okay, we've got 2 non-compliance cases before us. Let's see if we can get through those and be done.
Yes, sir. Non-compliance of board order. Hang on, here we go. Case number 15 on the agenda, code case 25-009693, property owner Casa Tessa Marina LLC, registered agent Robert Guarini, property address 60 Palms SQ, presented by Code Officer Delinda Wachowski.
Is there anybody present for this case?
Yes.
Okay, why don't you come up here, give your name and address, and tell us what your relationship is to the property.
Hi, good evening, everyone. My name's Robert Guarini. I'm the owner of the LLC, and I'm a local resident here in Delray. I live at Luna Rosa Building, 36 South Ocean Boulevard, and I'm here for an obvious violation.
Great,
unfortunately, and I don't know who addresses first, I guess.
Okay.
Good afternoon. My name is Delinda Witkowski. I'm a code officer for Clean and Safe. I'm here regarding case 24009693. I originally found in violation April 10th of 2025 for extreme hat racking. Of course, this violation was written a long time ago in 2024. However, because there were some issues and postponements, it was taken only on April 10th where they noticed the violation, and the board motion was for 30 days to correct the violation or $50 for daily fines thereafter. Compliance date was set for May 10th of 2025. On May 23rd of 2025, a board order was conducted and no permit was ever applied for. On September 30th of 2025, I conducted an inspection and the property owner was still out of compliance. So, the hat racking, no permit had ever been applied for. I have one initial photo and I have 3 photos that are recent photos that I would like to introduce into evidence.
Okay, before we get there, what is the total amount of fines today?
The total amount of fines is $9,000 and $9,050.
I'm sorry, one more time, please.
$9,050.
Oh, 9,000.
Okay, thank you. So we spoke about, you mentioned photos, so let's just show a couple. I'm just going to kind of scroll through these. These were previous violations, just refresh the memory of the board. These were previously introduced. So I think the exhibits are...
So it was found on August 15th of 2024.
This May 23rd photo, is this a re-inspection photo or?
That was the re-inspection photo after the code board, the first initial code board. So it was given 30 days and then a inspection was done.
Okay, so you did an inspection after?
After a board order.
Board order,
Mhm.
correct, just to show, so this would be really exhibit 1.
Correct.
For purposes of this hearing. And then you did another re-inspection, just showing the same picture, and the condition of the tree obviously has not grown back significantly since, August 2024.
Correct.
And it's still out of compliance.
Correct.
And then just refer to this as exhibit 3 is what is this?
Okay, so October 3rd, technically, he came into the city about 10 days ago,
About 10.
and we told him what he needed to do, and he made an initial attempt.
I did come in prior. I spoke with Mr. Glover, but that was under the time. It's a 35-year-old banyan tree. So the way we got here, unfortunately...
Let's let the code officer finish her testimony, and then you'll have a chance to ask
sorry.
the questions of her. And
We don't need to go that back. We'll just, so basically, he made an attempt of doing a permit, and it's not complete, but he is trying after a long period of time.
So this screen is just to show that he came in and applied for a permit on the 3rd,
Yeah.
correct? All right. At this time, the city would like to introduce exhibits 1 through 3 into evidence.
do I have a motion to that effect?
Okay, I make a motion, we accept exhibits 1 through 3 in this case.
Second. All those in favor?
Aye.
Any opposed? Okay. Sir, now you have opportunity to ask the code enforcement officer any questions you have or give any rebuttal testimony.
Sure. Thank you. It's a 35-year-old mature tree. We were giving it an opportunity to come back to life. I did apply for a permit, and I don't even know if everyone here might know this, but I was rejected on my application because as an owner, if it's in an LLC, it has to be a third-party company. So when I originally applied, it was rejected. So I did make an attempt. It was rejected. I have a group of emails that, if I have to, I'll put into...
Could you be specific about the rejection date?
It was May 13th, 2025. Application not accepted. So I obviously applied prior to that. This is my, application
notice,
rejection letter. So I have many correspondences over this time period with Miss Jerry Pryor, who is the lady that sent me the letter. That's why I was, addressing her. We were supposed to meet with the powers to be. I have emails back from her. She happened to be out of the office. So there is a history of correspondence. We just never got that meeting set up, and I could quote, like, I want to be in compliance. I hate to remove the existing tree. Are you able to, come to the property? There's a lot of emails back and forth. I have a hired licensed architect now with the city. Two things that I may make suggestions. One is these permits online now are extremely difficult for people to get. I went to college. I had trouble, so I'm not an amateur. But maybe if you could pay an extra fee and there's somebody here that could help you would be, extremely beneficial. And then the other thing he said, you need a licensed Delray Beach landscaper. So I said, can you recommend one? We're not allowed to recommend, which is true. But at least have a list where you could hand somebody a sheet of paper. We have 10, and you could choose from one of these 10. But it was very, very difficult. He applied, he had a hiccup with his secretary, gave some old insurance form. He has the new one, so he had to resubmit. I have pictures, I'm in compliance. The new trees are there, and it started out with one tree. Somehow it's at 4 now, so it cost, $1,500 just there. But anyway, I'm in compliance. The trees are moved. The new ones are there. I could show you pictures. I'm just waiting for the application permit.
Questions? So, yeah, go ahead.
Is he in compliance at
He
this
is
time?
not in compliance.
No, but
He is not in compliance. He has not, he did make, there are a lot of mistakes with the permit, but he does not have an approved permit. So technically, he should have waited for his obtained permit before he did. I did see photos that he did put the trees, he had to put trees that were 10 feet high, and 4 on the property, and that was what he needed for compliance. But he did that before he even obtained the permit. So technically, he has to obtain the permit.
I didn't know that the permit was going to take so long. I'm doing my best. Like I said, I've got email stacks and wanted to meet with people. I'm not ignoring this. I'm happy to. I even made an offer to donate money to an arborist fund for the city, and they didn't want that. But I tried to offer other suggestions as well.
That's why I actually emailed him, and I highly suggested that he be here so he can request for you guys a little more time to finish up everything to get obtained, to be in
the trees he
compliance.
installed are in compliance.
Well,
the
no.
trees that they installed would be sufficient for compliance if it was done in the right way.
Well, we don't know what the approvals are. Like, we can't necessarily say.
Landscape has to go out there
Right.
and.
Okay.
So it sounds like what Ms. Patalski just said. She's been in communication. He applied, although we were initially here for a fine assessment and request for lien. It sounds like Ms. Patalski is saying, look, he's trying. He just
Very much
explained
so.
everything that he's done. So maybe what we could do is, at this time the city withdraws it, and then we will place it back on an appropriate agenda if necessary.
That sounds acceptable.
It's going to get done very quickly. If not, it's done. I'm just literally waiting for this permit.
You
And I
could-
apologize.
you could stay
Cart
the
went
fine.
before the horse, but
You could stay the fine pending. It's up to you.
How about staying the whole case, which would include the fine, for 60 days?
Well, you can't stay a case, but you can stay the fine so that it doesn't continue to accrue.
Will he
I mean,
be
you
able
can't
to-
you can't reduce the fine at this point because that would be you'd have to go and do a reduction of fine, and that's only possible once the case is in compliance. But the only thing if you don't want the fine to continue to accrue, you could stay it for a period of time.
Stay it for 60 days?
does that mean I still pay the fine?
So you already owe the city $9,050. That's the fine. You have the opportunity, once you're in compliance, to come back to this board and ask us to
But I've
reduce that. Let me finish. So that's what's accrued in the time from when the board, and on all of us on this, we're on that case, I believe, back in April. When the board made that decision and notified you the decision was made, that fine clock started 30 days after that decision was made. Since then, it's been running. So that fine has been building up. But we have not put a lien on your property. So what can happen now is it sounds like you're making progress. If we stay that fine won't continue to grow, but it'll stay at that same amount. Once you've completed the process, then you can appeal to have that fine reduced based on having completed the process. Okay, you can't make that appeal now because you haven't fixed it.
I
But
hear
once
you,
it's
but-
fixed, then you can come back and ask us to.
But with these amount of emails back and forth throughout that time process, me getting a rejection from a permit, I'm showing very good faith here to process this.
And I understand that completely, and I agree that you are showing good faith. Once we've made that original vote back in April, once that 30 days has passed, if there wasn't progress at that point, which there wasn't, or not visible progress that the board could see.
But in May, I have
So I'm not going to argue with that. It's essentially the clock has been ticking since then. So that fine is sitting there, but it's kind of in limbo because no action has been taken. Okay? So what we can do is we can keep it from growing bigger. You can fix the problem, which you're already on the path to
It's
doing.
already fixed.
Right?
Okay.
You're on the path of doing. Once that final permit is approved and the inspection has taken place, then it's done. And then you come back and you ask for that fine to be reduced.
Okay, I'd like to submit my emails into record.
I mean, do we want that?
I think it's premature because this is the city's hearing. I mean, does the city? I mean, I guess
Well, I believe I don't know if it's relevant or necessary for this hearing. If he were to come back and ask for, I think it would be more appropriate in a reduction hearing, or even to say that, you know, he can come back then and say that this is where the fine should have been based on this date,
Right,
etc.
right.
I think that they would be more appropriate to be introduced at that hearing. So I would object and just ask, you know, maybe to hold off until
Just
the
hold
appropriate.
that until that fine reduction hearing, which, you know, hopefully will.
I mean, I'm in
be at our
compliance
next-
right now. If this process was easier and somebody could give help to a citizen that's trying to be in compliance, I mean, I have a litany of emails going back to say.
So, sir, what we're suggesting is you hang on to that because the chairman's explained our process, and you have not been leaned at this time. So you are accruing a fine, and what we want to determine is what's it going to take for you to come in compliance, which would be to obtain a permit, and that's already been decided. So our decision today would be whether or not to lien you for that fine, and in our discussion, we're leaning towards staying the fine temporarily and giving you an additional 30 days to come up
60 days, I think.
with the permit. And then after that happens, and the code officer reports to the board that you're in compliance, then you can come back on the agenda, and I think you were here at the beginning, right, of our meeting today?
I was here, since
So you
1:30.
heard the chairman say, we're not here to fine you, we're here to see you get into compliance, okay?
Okay, and if it was, sorry.
So I'm almost done.
Okay, go ahead, sorry.
So we do care about you as our fellow citizen, and we're hearing everything you say, and all the legal people that are here have suggested you hang on to that material when we get to that point together.
Okay, and you know, it's not easy. I mean, I applied for the permit online, I can't do it, no one's, I had to get a survey.
Well,
I had
that's
to
why the
hire a
board is
licensed
considering
architect.
not imposing a lien on
Okay.
your property at this time because
Thank
of your
you.
effort.
Yeah.
So, do we have a motion?
Mr. Chairman, I'd like to make a motion that at this time we will stay the fine will not accrue, and the resident would have 60 days to continue working with the code enforcement officer to bring the property into compliance by obtaining the proper permits.
And if I just added,
Yes.
if it's not done in 60 days, then the fines will.
If it's not added in 60 days, the fines will continue to accrue.
Correct.
$50 per day.
Second.
Second.
Any further discussion? All in favor?
Aye.
Any opposed?
Thank you.
So thank you, sir. And
Good
you-
luck in getting your permit, sir.
Yes, we understand that it can be challenging if you're not a professional at it.
Even the
it's-
people here don't know with the new system.
Yeah.
So,
Well-
so he went back, and the lady here was, the reason a lot of it's not processed is because I owe money to pay, and she didn't know how to send them a receipt. So it's,
Yeah,
We'll
it's
work with you.
it's
It's
a
okay.
challenging process, but that's why we're trying to work with you. So,
Rome wasn't built
Thank
in
you,
a day.
Robert.
yeah.
what's that?
Rome wasn't built in a day.
And the online process is a step towards getting better, but it
Let me
doesn't
ask
mean
you-
it's perfect in their first try.
Okay, but one other question. The
Yes.
original letter was replace it with one tree. How did it arbitrarily go to 2 to 4? Is it going to be 30?
I'm not an expert on this, but my understanding is that you're replacing the size of the trunk, and so it really is not the number of trees,
'Cause the
it's the
letter-
amount of
okay.
outside
It's
perimeter of the
probably
trunk.
best if we're not getting that.
And I want to just address one other thing. If it was a banner, I would have took the banner down. It was a 30-year-old tree that I wanted to see
It was a
come
living
back.
thing that was killed.
Yeah, and I felt terrible, and it was a landscaper's miscommunication. It wasn't like I said, racket my tree. So it was truly an accident, and I'm sorry for that.
We appreciate that, and then that's why we're trying to work with you here.
Thank you.
And we look forward to seeing you at a future meeting so that we can work
Thank
with
you.
you some more.
Thank you, Robert.
You all right? You need a break?
A couple of sneezes,
Oh.
allergies.
Something's been
seasonal
bothering my
change.
allergies in here too. So
Yeah,
there's something in this
in
room. Yeah.
It's because we've been here for 4 hours.
No, something's
Too
going
long
on.
in this room.
We got one more case.
This is the last one, everyone, and then you can go have dinner. Case number 16 on your agenda, it's a non-compliant case, code 25-003321, property owner Joseph Cadet P. Property address 24 Northwest 7th Ave, presented by Code Officer Delinda Witowski.
And anyone here for this case? I'm sorry for you having to wait this long.
I don't know if you were sworn in, because I remember, did you get sworn in last time?
No, because you asked for those who are giving testimony. I'm an attorney, so I'm not giving testimony.
Well,
But if you want me to,
Yeah,
I have a right hand.
Let's go ahead and get you sworn in. Won't hurt.
If she's not giving testimony, she doesn't have to be sworn in.
We don't know what'll come up. It may wind up being testimony. So.
All right, swear me in.
By the authority vested in me as a notary of the state of Florida, do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And your name and address for the record.
All right, I'm Tanika Reed Williston. My office address is 505 Royal Palm Beach Boulevard, Royal Palm Beach, Florida, 33411.
Thank you, Ms. Wilson. Ms. Witkowski?
Hi, good afternoon. My name is Delinda Witkowski. I'm a code enforcement officer for Clean and Safe. I'm here regarding a case number 25-000-3321, which was originally found in violation on July 10th of 2025 for a damaged fence on the at the back of the property. The board's motion was for this case was given 30 days to correct the violation, or $100 per day thereafter for noncompliance. The compliance date was set for August 10th of 2025. As of October 1st of 2025, I conducted a re-inspection at the property where the violation continues to exist. I have one initial photo, and I have two photos that were recent on this case that I would like to introduce you guys into evidence. As of October 9th of 2025, the case is still out of compliance, and there is an accrued fine in the amount of $18,100.
Oops. So I'm just going to show the board some old photos of the property back from May 28th, 2025. All right, so now I'm showing you updated photos. It should be marked as Exhibit 1, taken on August 15th, 2025. Could you please explain or describe what's depicted in the photo?
All right, so this is on August 15th of 2025. You'll see that the fence has basically just, it's bent, broken. It's a chain link fence that just needs repaired or removed.
All right, City Exhibit 3, I'm sorry, 2.
So this is October 1st. That was taken on October 1st of 2025.
All right, at this time, the city would like to introduce the two exhibits into evidence.
Mr. Chairman. Yes. I'd like to enter the two exhibits into evidence. Evidence, I'm sorry.
Second?
Second.
It's been a long day.
All those in favor?
Aye.
Any opposed? Thank you.
So just yes. This case is in pro bono. No, probate. Probate. I apologize. And I reached out to the law office yesterday, and so she is Ms. Reed, right? Has been given authorization to represent, and I have a letter from the city's attorney's office that I don't know if you introduce it into evidence or just so you can look at it.
This is the authorization. We don't object to her representing the client.
Okay. Thank you.
All right, anything else in the city?
No, that's good.
Okay. So you have a chance to question the witness or to provide any rebuttal testimony.
So mine is we're here for a request. I don't have any testimony to offer or even much question. As Ms. Belinda just explained, the owner of the property is now deceased, and his family members, including his wife, have opened up an estate. That takes a little bit of time. So now a letter of administration has been issued. The wife has been appointed as a personal representative. They have petitioned the court for permission to sell the property, and I believe that they're in the process of executing a sale. The sale has not yet been completed, and at this time they do not have any funds to pay any fines or to make any improvements at the property. So that's the predicament that they're in. At this time, they're requesting 30 days to finalize a sale of the property, and at that point in time, they will address any fines or issues that still remain with the city of Delray Beach. including a request for waiver or reduction.
Does the city want to respond to that?
Yeah, I mean, I hear the predicament, but the city's concern is that, you know,
Safety.
Obviously safety and things like that. The property is, you know, in poor condition in the area, so we just ask that you know, find that the property is still out of compliance, assess the fine of the $18,100 and put a lien on the property.
I mean, that's not, while I can understand the request, that's not really conducive. I mean, at the end of the day, the whole time I've been hearing, we're not here to find, we're here to get you guys into compliance. I've explained the owner of the property is deceased. There is no income for these individuals to get the property up and in a state of compliance, as you would call it. So assessing a fine of $18,000 to a family who's already lost a breadwinner is really not conducive at this point and is not really beneficial. It's more punitive than anything else.
Question: is there a contract on the property, and 30 days it will close? And
yes, they have already taken the steps. So yes, they do have an offer to purchase. And with probate, again, everything is step by step. It's not just like a private agreement where you and I can agree and we can say inspection in 3 days and you move forward. With probate, you have to petition the court with the proper documentation, showing them an appraisal. So they have to get an appraisal. You have to show the appraisal, show all the documentation, and get a court to agree to that, either by going to a hearing or by submitting it. And the court, of course, there's a backlog, so they take a little bit of time to assess and then issue a ruling. The court has given them the order to go ahead with the sale, so they're in the process of finalizing a sale.
Ma'am, what are you asking the board to do?
30 days. We're requesting 30 days.
30 days of what?
30 days in order for them to either come into compliance with this, come into compliance or finalize the sale. And by them finalizing the sale, they will have the monies to actually come into compliance.
I mean, the order violation already exists and the fine is accruing. So what are you asking the board to do? I mean, the city's asking the board to certify the fine amount into a lien, which I'm gathering that you would prefer the board not do, but what specifically are you asking the board to do?
So I request that the board, of course, not place a lien on this property at this time. I would request that the fine be waived or reduced, but based on my understanding from what has been explained before, you have to come into compliance before I can request.
The board doesn't have the power to do that at this
a reduction.
Stage. Yeah.
So I'm requesting
you're
that no
asking
lien
them
be placed.
to not assess the lien.
Correct.
Okay.
So what I would say is, technically, you know, if the board does not assess the lien, they sell the property tomorrow, the fines don't travel with the land, only liens do. So then, you know, it would just be like nothing happened, right? It would kind of go away. There's no need to even come into compliance. It would have to, you know, we would have to restart with the new property owner and restart the same case, right? So, you know, our goal is compliance, and we want to encourage this, and this is a safety issue, a nuisance issue within the city. So, you know, that's why we're asking what we're asking for.
I have a question. Yeah. If we give them 30 days to come into compliance, but enforce the lien, can they come back and ask to have the lien lifted at that time?
Yes, they can ask for a reduction. They can ask for, like, the new owner can ask for, you know, they would, you know, not to get too deep into property sales or real estate, but the new owner, they purchase the property subject to the lien. They can come in and ask for a reduction to pay it off, or, you know, sometimes they even do it like in escrow. There's different ways to handle it. Like, I'm not, you know, I'm just...
Yeah, it is not uncommon for a new property owner to come back to a code board or a special magistrate and ask for a reduction of lien. In fact, it's...
Just for clarification, right? On a sale of a property, if there's a lien, when it comes up in a title search, the new owner will have to address that lien.
That's a lien, not fines.
Right.
There's a difference. Right.
So if we lien, but...
We don't have a lien yet.
We don't have a lien yet.
So. Jimmy, I have a may I comment?
Yes.
Thank you for representing these respondents. I have a problem with it because you're not offering an alternative to resolve the problem, and which is the safety issue of the fence. So there appears to be no willingness or alternative action on the part of the owners at this time to repair the fence. whether it be by themselves or whatever method, can't prescribe. But I don't hear anything about how the problem could get fixed. So by not imposing a lien, we then have absolutely no motivating factor going towards getting the fence fixed. The situation aside, does that make sense?
It makes sense. I think either way, there is no motivation factor, right? If they sell it, it's going to come from the proceeds.
No, a lien or the fine?
Or if we do go forward with the lien and the fine, right?
Right.
It's just going to come off from their proceeds.
Right. When she hasn't offered, well, when we sell, there's X dollars, and
correct.
That so that's my problem with what you're offering. There's no answer to how we fix the problem. We're not really here to take money from people. We're here to see it get into compliance, and we're not hearing how it's going to happen. Sorry.
One more question. To bring compliance, if someone goes out there and just takes down the fence, would that bring it into compliance?
I have to look at the original violation. It's maintenance of property.
Yes, it's maintenance of property.
Overgrowth and
It's
everything?
overgrowth.
No, well,
Okay.
there are several violations on both the properties that are together that are being sold. So there are several violations, and landscape is one. But technically, yes, if they remove the fence, it does come into compliance.
Just so we're clear, if they remove the fence, the landscape and stays the way it is, it will come into compliance.
If they remove the fence.
Yeah. But the
For
landscape
for this violation. There's several others.
Multiple
There's
violations.
That's the only thing we can
That's
talk
what
about,
we're
right?
not talking about any
Yeah,
other
we're
violations
talking about
right
this
now.
one. So,
This one,
question
yes.
to the
This case is just the fence.
right.
It's just the fence. Yes.
Question
And
to the, do you think they would object to getting someone out? I do understand the financial situation, but removing a fence could just,
how
because
big
we're
is
looking
the
for some type of solution, because if we don't do nothing, like the city attorney said, they're gonna sell, it's gonna be someone else's problem.
What we see here
So-
in these photographs is a small section.
Mm-hmm.
Are we talking about hundreds of feet of fence?
Yeah.
What are we?
How
We
big is
never
this
really
fence?
saw it on a map.
it's probably 10 feet of fence that needs to be repaired.
10 feet of fence, is that what you said?
Yep. For this property, yes.
On this case, we can only really talk about this case.
One last question. How long before you plan with probate and closing on a property?
I'm sorry, can you ask me again?
How long before you'll be done with probate and closing on the sale of the property?
Okay, so how long I'll be finished with probate?
And the
I
sale
don't-
of the property?
Oh,
Probate.
the concerning the actual sale?
Yeah.
So honestly, there's no way to answer that. There are different factors, but these people they have already had a contract. I believe escrow has already been deposited. The court has already said yes. So it appears that they're marching towards the finish line. That's the best answer I can give. I don't have a timeline. The biggest factor generally is waiting for an order from the court, and that has already been they've already received that. Concerning Mr. Gutierrez's concern that he doesn't see any progress, I'm not sure how to respond to that. I mean, it's digging up a fence. It's not like digging up a plant. That's not my specialty. I personally would not be volunteering to dig up a fence because I imagine it's hard. You have to pay somebody to lay it down. I imagine you need to pay somebody to remove it. I can ask the individuals if they're able to remove it themselves, but the main issue here was money. That's always been the problem. They do not have the funds to pay somebody to go out there and address whatever the violation is at this time, which is the fencing. You talked about safety issues. While I can appreciate there is a hole in the fence, I mean, this doesn't seem like an attractive nuisance where we're going to have little kids running into the property. We don't see any trampolines or any pools there. So I don't believe, that we're going to get into that kind of weeds. I appreciate the look. It does not look great. So I'm with you there. But I think the city can, we still can address the fines without placing a lien on the property. You place a lien on the property, it makes it a little bit more challenging to complete a sale.
Okay, I have a discussion for the board.
Yes.
How about the fines will continue to accrue and we just don't lien the property? No?
I don't think so, because what
If they
happens,
sell the property, the city has nothing to
So we
claw
do
back
need the
at.
lien to, okay, that makes sense.
But
Thank
does
you.
it prevent the sale of the
From
property
going
for them
through.
Yes.
paying the fine or
Yeah.
paying a reduced fine?
this must happen all the time. People have liens on the properties get sold. In my professional experience, I have experience with this
Yeah, to
within the city of
satisfy.
Delray, and so probably does Jimmy.
Right.
Which makes me concerned that based on what we can observe in the photograph, based on the levity of the fine, that if we pass on it, it's just not going to get done. So
So the thing is, if we fine it, does it delay the sale? If it delays
That's
the
really
sale,
not
the
our
fence
problem.
is going to be there longer.
it's not our problem. And the answer to that, from my personal experience, I can't speak to this specific case, but not really. Doesn't really. They'll work it out.
So,
Go ahead.
so let me understand. The city's position is that you guys place a lien on the property for $18,000. Is that the city's position?
Yes, it's the
We
city's
haven't,
position.
yes, I mean, that's the city's recommendation. We have not, as a board, made a decision yet. We're discussing this, so.
So, if I may ask the question, if you place a lien on the property gets sold, they make the necessary adjustments. How does that lien get is there a mechanism for having a waiver or reduction of the lien? Because at that point in time, it appears that the estate might lose the advantage of coming back for a reduced.
If I could speak to you on that, it's been presented in an earlier case just before yours. We discussed the process, and when you were here for the opening, the chairman said, it's our goal to get you into compliance, not to fine you. We're not here to fine you. However, it looks to us as a board that this is not going to be resolved unless we put a lien in place.
Mr. Wagner, can you address the
Yeah,
specific?
so under the
is there a
code in
process?
chapter 162, once the property is in compliance, the owner of the property can come back and ask this board to reduce the fine, or to reduce the fine to a set amount or to zero, and then it becomes up to the discretion of the board on how to do that. But the board can't do that until the property is in compliance.
So can I?
And just to clarify, that it's the then property owner, whoever that is, when the property is brought into compliance, that can come back before the board. In this case, if the property were to be sold, and I think the concern here is that if we put the lien on, that the monies to satisfy the lien would come out of escrow to the detriment of the current owners and not to the present owners, or to the new owners. The new owners would be the only ones who could come back and ask for more money.
Well, I mean, these things can be negotiated, but I'm not in a position to give the
I'm not asking for advice, but I'm
on how
just
to do
trying to
this.
clarify the issue, right?
But this is not a new situation.
Yeah, just from my understanding, if in 10 days they take the fence down, they come back, the property's in compliance, at that point in time, they can ask for a reduction of lien.
They could.
So I think what we're asking for is, can we take, because if not, we're just going to pass it to the next owner, or nothing's going to be done. So do you think it's feasible for your clients to remove the fence before the sale is completed, therefore you can come back and ask for a reduction of lien? Or fine, I'm sorry.
I can certainly ask. I mean, I can certainly ask. That seems as if it's a fair compromise, I would venture to say. I don't have the authority to say yes or no, they can do that. I can ask if this court would allow me, or if this board, would allow me, I guess, 30 seconds to make a phone call.
Because I think what the chairman is saying is, if you come back into compliance, we're going to be extremely open to reducing that lien. Is that fair to say, Mr. Chairman?
I think that's accurate.
Okay.
The only protection the city has is liening the property.
Correct.
If you don't place a lien today, they sell the property, the city doesn't collect a penny.
Correct.
But the double-edged sword is that if we place the lien, the property sold, you come back, we're not going to forget you, and we're going to try to be as fair as possible. So it's kind of a double-edged sword for all of us.
The one thing the
sitting
board
here.
could do is what you've done previously, is you could stay the fine from continuing to accrue. You can certainly do that
So we
at this
could do a
stage
stay,
if you
give up
want
30.
to. The you can't reduce the accumulated until they're in compliance. The city's asking you to lien, and you know the implications of leaning or not leaning, so that is a decision that you have to make.
So let's talk about his motion. Do we want to stay the lien?
Give them stay on the
Stay
fine.
the fine.
Stay on the fine, put the lien on it.
Apply the lien, stay the fine, and then
Give
as
them
a
opportunity
board,
to come
you know,
back.
we're compassionate. We have to try to protect the taxpayer's interest also. And we're sympathetic to the loss of the gentleman, so it's really a tough decision.
Yeah.
I understand.
Understand.
So do you want to make a motion?
Make the motion.
Come on, Mr. Chairman,
Yes.
I'd like to make a motion with respect to case number 003321. I move for finding. Are we putting a lien?
Yeah, put the lien.
This is
Yeah,
the wrong
different
one.
motion.
Sorry.
You're going to stay the fines.
No, don't we have
But
one for?
we have one
lien?
for lien, yeah.
We have one for lien. I'm sorry. I don't
You should have one, I wrote.
I need it. I don't have that for some reason.
Number 3. Motion 3, right?
Motion to assess penalties and lien continue. Mr. Chairman, I'd like to make a motion with respect to case number 003321. I move for finding of fact and conclusion of law that there is good notice in violation of the fence safety issue continue to exist on the property, and based on the previous order, a fine of the amount of $18,100 will stay, and a lien will be levied against the property and property owner, and no daily fine will accrue until
For a period
of
what do you
30
want,
days.
60 days?
60.
I mean, it may take them a while to get everything resolved.
Ma'am,
but-
are you good with 30 or 60 days?
60 days, but I guess I want to hear, I'd take 60, but I want to hear the full motion before, so I can answer properly.
Okay, levied against the property owner and no daily fine for the next 60 days until the property comes into compliance. The respondent shall immediately notify the code enforcement officer when the property is brought into compliance.
And if we can add, if it's not corrected.
If it's
within 60
not
days,
corrected within
fines
60
will
days, the
continue
fines
to
will
accrue.
continue to accrue.
Second.
Thank you. Any additional discussion of the motion?
I have-
All those
I
in
have a
favor?
question.
Aye.
Any opposed? Hearing none, the motion passes.
I have a question. So with the stay, because you're already putting a lien on the property.
Right.
So with this lien, it is the current property owner who can come back and request, and negotiate the lien?
Once the issue is resolved, in this case, the fence is resolved, either repaired or removed, or whatever else is needed for the city to have it in compliance, whoever is the owner at that time can come back to this board and request reduction of that lien. Removal of the lien and reduction of the fine.
Okay.
Thank you. Appreciate you for coming.
Thank you for coming here and representing them.
And my
Thank
thanks
you.
to all the board members and to the city staff. This has been a little bit of a grueling session. I know we got postponed from last meeting, so we had kind of double duty this time, and appreciate all of you putting
Good
the
job,
effort
Mr.
in.
Chairman.
So
Well done,
thank
Mr.
you.
Chair.
And you did a great job.
You
Can I
did a
get a
great
motion to adjourn?
Motion to adjourn?
Ooh, that seems hot, huh?
Good job.
Technically, you have to.
This is a slog.
Wayne's paying for this.
Yes, he is. He owes me a free meal at least.
We need snacks. We need Snickers. Ms. Pryor. We need cupcakes. We need,
did need the cupcakes.
No, you did it.
we need the cupcakes today.
You're doing a good job.
Thank you. Thank you.
See you guys next month.
She's at home?